I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Standing for invocation. We gathered together here today, intent on doing good work. We seek to represent fairly and well those who have given us this task. May our efforts be blessed with insight, guided by understanding and wisdom. We seek to serve with respect for all. May our personal faith give us strength to act honestly and well in all matters before us. Amen. Thank you. Before we move on to business, I want to, because it's kind of related to this next piece here, I want to thank Lori Wolf for her service. She has spent 4 years on the LPA and decided to move on. And we welcome Dan Allers, our newest member, to the LPA. You're welcome. Dan, you want to tell us a little bit about yourself?
I'm, other than the obvious, I'm pretty sexy. No, I've been an island resident for 8 years now. Most recently, I've been on Board Cab Committee. Last year, I took a run at Town Council, came up a little short. Other than that, there's not a lot. I've probably met most of you as I walked around last year and knocked on your doors, but I'm an open book. If you need to reach out and ask me any questions, you know how to get a hold of me.
Thank you. First meeting order of business here is to reorganize chair and vice chair. Do I hear a motion?
I move to nominate Megan as chair.
A second.
All in favor?
Doesn't need a second. I move the nominations be closed.
Are you,
Well,
all in favor, say
you don't need to second the nomination if there's no others. I just move the
It's already been
nominations be
seconded twice.
closed.
Okay,
For chairman.
okay. All in favor?
well, it's closed. All in favor, say aye.
Aye.
Aye. I make a motion to nominate,
Oh,
go ahead.
I nominate Jane Plummer for vice chair.
Second.
All in favor? Aye.
Thank you.
So moved. Thank you. Moving on. We're going to open up the public hearing for the Dune walkover. Oh, wait a minute, time out.
Approval of the minutes.
Approval of the minutes.
There's a correction that needs to be made on page 3. It's actually, I'm the one that actually voted against the publics, not Jim.
Did you get
In the
that?
packet, it's listed as page 5.
Page 5 on the packet, excuse me.
Yes,
Jason, you have that? Any other changes, discussions, questions?
Approve the minutes as corrected.
Your second?
Second it.
All in favor?
Aye.
Aye. Okay, now we get to move on.
Madam Chairman, we had another Dan when I first came on the committee. It was Dan Hendrickson. And it caused a great deal of confusion. And when I first came on, he was the younger Dan and I was the older Dan. Yeah,
You still are the older Dan.
I wasn't particularly thrilled with the appellation of being old Dan, although I am. And so I just think we ought to be clear and have a Dan 1 or Dan 2 or Dan Senior or Dan Junior instead of
Dan H, Dan A.
Dan.
My dad's name is Dan as well, and he's referred to as Big Dan, and I'm Little Dan. So
That could be confusing.
that works for me if it works for you.
That sounds fine.
Okay.
So Big Dan
I
and
like
Little
that.
Dan. Do I
Big
have
Dan,
this
I like-
straight?
Big Dan and
Little Dan.
But he's bigger than him.
Yeah, that's
But
beside
that's
the
the
point.
irony of it all. Isn't that fun? All right, I will do my best. If it becomes Mr. Hughes and Mr. Allers, that's what it becomes. We do have a considerable amount of people probably coming to testify. Do we want to do one swearing in?
Yes.
Okay.
For anyone who's going to give any testimony on any of the items today, if you could stand and be sworn in. Do Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? All right, the witnesses have been sworn.
Thank you.
If by chance anyone gets up to give public comment and they haven't been sworn in, please state so we can get you sworn in at that point. Otherwise, we're ready to go.
Okay, thank you. Now that all the administrative stuff is done, we're going to open the public hearing for the Dune Walkover Boardwalk at 8150, 8170 Estero Boulevard. I'm going to call for ex parte communications at this time. Big Dan?
Would you come back to me a second? I'm fumbling through my
I'll start
notes
to
here.
hear you.
A site visit.
Dan,
Drive by Google Maps.
Site visit.
site visit.
Site visit?
I've had discussions with the representatives of Texas Hold'em and representatives of, what's the other petitioner's name? The Squeeze Me In.
Anyone else have communications like that?
I also have
similar, other than
Communications with
communications, other than calling it a site visit?
During the site visit, I had communications, yeah.
Yeah.
One question. Were you builder for the property? Were you builder on either property? Okay. Okay. I spoke to Gary Lau, but I thought he was builder of, not builder of either property, so I just wanted to verify. Okay, thanks.
Okay, so have all ex parte communications been,
To the extent that any of the, or apparently most of the LPA members have had conversations with the applicant's representatives, just to remind you that, this is a quasi-judicial proceeding, so therefore your decision should be based solely upon what you hear here today. And you cannot consider the statements that were made to you outside of this hearing. It may be valuable to you all in the sense of background information, but it cannot be and should not serve as the basis of your decision today. Should only base your decision upon what you hear here today, and any testimony and evidence that's presented and put into the record. That's in fact the whole purpose of disclosing the ex parte communications, is that while you had them, you're stating that they aren't going to have an effect upon your decision-making process, and you'll limit your consideration to what's here presented today. So,
I have a question for the council. I have I have written information that's been not submitted by staff. There's no prohibition against me considering what I've received there, is there?
unless it was submitted as part of the application, yes, you cannot consider it. Unless it's part of the record.
Of what record?
Of the record here today. What you hear today or what's been submitted by the applicant, anything outside of the four corners of the application and what you hear here today should not serve as the basis for your decision.
Well, that raises a serious concern in my view, very serious concern.
Yes, it does.
And that is the fact that I have a 71-page, very detailed history of this whole situation and the finding as an administrative judge, and you're telling me that we can't consider that?
If it's part of the application, and I would defer to staff, then yes, you can consider it as it relates to the criteria that you have to consider here today. So to the extent that it was submitted in the application, then it's part of the record.
I
And that's
believe
my-
what
and just-
I believe he's talking about is we see 5 pages of that judicial order in our
Correct.
packet here
So-
of 71 pages.
Yeah.
And the question is, was the 71 pages completely submitted?
My understanding is it was.
And why didn't
So-
we get it?
I'm sorry?
Then why didn't we get it?
Because I believe that staff, at least in the staff report, have provided to you all what they believe is pertinent to the issues at hand. I would point out that in the order that you're referring to, there are several statements throughout, and ultimately a conclusion, and part of the order is that whatever that proceeding was, still does not excuse or stated affirmatively, the applicant still has to come before you all, and independent of what took place at that hearing, have to demonstrate entitlement to the special exception and any other permits that they may need in order to move forward with the project. And to the extent that you all maybe didn't hear that from the applicant, I'm telling you, they certainly have but that is the whole reason why we are here, is because that issue was raised, and the administrative law judge and ultimately the Secretary of DEP in his final order said the applicant has to come before you and demonstrate compliance with our local rules. So, stated otherwise, the final order in of itself cannot constitute evidence that they comply with the code. They have to appear here before you and present competent substantial evidence, even if it is through that order or part, and demonstrate to you all that they meet the requirements of the code for entitlement to the special exception.
So if I'm reading this, hearing this right, is that you have gone through the 71 pages and provided with us the pages that are pertinent to what's being seen here before us today. The rest of it is irrelevant?
In the opinion of staff.
Well, it's not in my opinion, and I
agree.
find, yeah.
That is fine, and that is why the applicant is here before you to make their case as to do they meet the criteria and the special exception criteria or not. That is what you're here for, is whether or not the applicant, after all the presentation and whatever evidence, including a copy of that order and any references they make to that order, demonstrate compliance with the special exception criteria. The approval, the point I am trying to make to you all is that that order in of itself is not evidence that they meet the requirements for the special exception. And
I don't disagree with that, Madam Chair, at all, but I find it disingenuous that the staff chooses to just take certain extract from the 71-page opinion of and submit what they think is relevant. To me, I have a little concern about the fairness of that. If we're going to get part of this Attorney General's thing, we should have, I don't mean the Attorney General, I mean the administrative judge. We should have gotten the whole package.
Again, I'm not trying to make excuse. I'm here to advise you all.
Question.
But at the end of the day, within that administrative order, or that order issued by the Department of Environmental Protection and your code, the applicant has the burden of demonstrating that they meet the requirements for the special exception. How they get to that point is up to them, and you all give any of that evidence and testimony, including the order, the appropriate weight that you feel it should be given in reaching your final decision.
So can I call ex parte communications and find out who all's read this 71-page that was provided to us? To
Sure.
find out who here on our board has read the 71 pages?
Sure. I mean, if that's,
I just want to
if
see
there's someone
who's seen
here
it and who hasn't seen it.
Yeah, and who hasn't read the entirety of the document and feel that they need the opportunity to read it in order to make a fair and impartial decision, then we take a break and we read through that, or we take up the other matters and then take a break. It's up to you all if you believe that's what you should do.
Well,
Other members don't have it either.
that's why I'm calling. As part of ex parte communication, I'm calling it again. Who's read the 71-page lawsuit or judgment?
I have it, and I have a copy of it with me.
Dan?
I have not.
I've not.
I have.
I have a copy of it.
I have.
And to those who have not read it, do you feel you need this in order to?
Absolutely.
Okay, so what I'm going to do is I'm going to punt, and let's take care of the other business first. We'll break and give you guys some time to read it, because and then this is not a question, it goes away. The question goes away.
Correct. Yeah, if, the point is well taken. If any of you all need a complete copy of that document, the applicant can provide it to you all.
Is that acceptable for the committee?
I think that's fair.
No, staff, just as a side note, again, staff has indicated, and Mr. Green can speak for himself at the end of the day, but what portions of the staff, of that document that you have in the staff report, it's what was provided by the applicant in that format, and staff, according to Mr. Green, just transfer that into the staff report.
So we only
as they
got,
received it.
Correct.
so if that not all 71 pages were submitted, and that those
No.
were submitted as
So
is.
those separate pages were
Yeah.
attached by the applicant to the actual application, and it appears to me that's what they were finding and reference and relevant to their discussion and their application, their findings. I believe there's references to those pages in their narrative in addressing the criteria for the special exception. I've also quickly seen their presentation. It seems there's references mostly to those pages in those. So that's why we did not pick those pages. We did not isolate those out. Those are the pages that they chose as the
To
specific
answer those
references.
specific questions?
Correct.
Okay. Were the 71 pages submitted in evidence, is what
Yes.
we're asking? Okay.
They're included with the volume of
Okay, then
documents.
I-
But those pages were not chosen by staff. They were chosen by
Chosen
the
by them.
applicant. Correct.
To provide a narrative to answer the questions to the special exception
Exactly.
per each section of the special exception
Yes.
conditions? Okay.
Correct.
Okay, so we'll allow that and we'll break. In the meantime, we will move forward, and I'm not sure if I need a motion. Do I need a motion to move the agenda?
Well, could we hear the thing and then read it and then, and go through?
Good, I've read it. Who done?
No, but this is, they have.
Maybe we should
What is this?
hear those.
What are we getting here?
Okay, we're going to call you up, name for the record. I apologize, folks, we just want to make sure we dot our i's and cross our t's on this one. Go
Good
ahead.
morning. My name is Amy Petrick. I'm with the law firm of Lewis, Longman & Walker. I represent Texas Hold'em and Squeeze Me In. I have provided each of the members a binder that has within it a PowerPoint that I have submitted to staff in anticipation of today, as well as all of the base documents that are referenced in the PowerPoint, which includes sections of your comprehensive plan, sections of your land development code, your zoning code, exhibits from the administrative hearing, and the final order, as well as the permits that were issued from the state relative to this project. So hopefully that will assist as you go through the hearing to understand the applicant's position.
Do I need a motion to move the agenda?
I'm sorry, to the extent that you called up the item, it would be appropriate to table it,
Okay.
and we'll,
All right.
Being the fact that they have mentioned if they have a PowerPoint presentation, we as a committee, will we see that PowerPoint?
Yes. we
Today?
will. Today, during their point, when they present their side of the case, then
Which
yes.
is pretty much everything that's in this book.
it's one of the,
Yeah.
the PowerPoint presentation has been printed out and put into the
Section one.
binder. It's the first document in the binder.
Okay, so,
My question is, you know, I know everybody's here today to speak, and it would be, I'm wondering if it's reasonable to say, why don't they present and we delay, because how long is it going to take us to read 70 pages? I don't know. I mean, I don't think that seems reasonable. And
Ron?
it is this, you know, staff didn't put it in, so I feel that it would be unreasonable to have everybody sit there and wait for us to read this, that has taken the day off or come here for whatever.
If I may, in the PowerPoint presentation, there are quotes directly from the administrative law judge's order, the consolidated final order, with page references, so that you would be able to follow along within the document itself of those findings that we believe are relevant to issues that are raised in the special exception application. So I just offer that as a piece of information as you decide procedurally how to move forward.
Would you think that in the presentation that you're going to give us, that it will cover enough of the whole package that we will get the gist of this? Or will you feel that your person is getting a just representation without us reading this?
We have attempted to extract and put in the PowerPoint everything that we felt you needed absolutely to hear. The 71 pages, probably half of that dealt with procedural administrative issues in that case that do not relate to the land use issues that you have in front of you today. So I would think that you would get maybe not 100%, but very close to it from the PowerPoint presentation itself.
Well, my suggestion would be then to go ahead with the hearing, and then the three of you that have read it, maybe make a decision at the end if you feel that what you heard represents this well enough for us all to take that at its word, or if we need to stop and read more.
That really comes down to, and this is why I asked who had read it and who hadn't. If
Yeah.
you guys feel that you are okay moving forward, I'm okay moving forward. You know, it really comes down to those who haven't read it, how they feel about it, which is the
I'm
three of you.
uncomfortable with it, but if it's in the presentation and three of you have read it and can bring up other things that have come from it, or feel you need more explanation, or if we need to continue to a later date so that we can all read it and come back. At least these people haven't wasted their day in being here to speak and represent the case, but I do feel that we have not been given all of the information to make a fair decision.
If I may.
Yeah.
You know, as much as I think that sounds practical and at first blush logical, I would caution this board that it is the responsibility of the applicant to demonstrate compliance with the code. You all are the impartial decision makers, and you make a decision. You should not look to each other to be persuaded, well, I read this and this is what it says.
So it's not our job to argue either side. It is our
Correct.
job to weigh. Tough decision here on whether or not we're going to delay it. Now, I guess the question is, we're talking, you know, by the time we go and hear these other two, it'll be some time before we get back to this. Is this something that you want to wait around for, or do you want us to move forward?
Madam
And
Chair, just a thought. Since the petitioner feels as if the PowerPoint appropriately captures the information in the 91 pages, I'm comfortable with that because it's their opinion that it does. But I would yield to those who haven't read it if they feel strongly about it.
I would agree with that statement.
I've been kind of
Yeah.
breezing through it, and the first 10 pages, it's nothing that seems very, important to what just a lot of background information.
Oh, well, you haven't read the important part of it.
I
I
don't.
read what we were given.
I'm not suggesting how you all should read it, but I will tell you that personally, having gone through more than my fair share of those types of hearings and reading those orders, sometimes I start at the back and read what the court ruled,
The final rulings.
the final rulings, and then kind of work my way to the front. Understand what the rulings were, may make it quicker for you to digest the information. Just a
I do that.
suggestion. At the end of the day,
I do that too.
you all have to feel comfortable with having the information before you in order to make an informed decision.
Well, that being said, is the last 1, 2, 3, 4, front and back? No, wait a minute, there's still more, sorry.
Right, it comes down to those who have not read this. If you feel you need to read it, then we're going to move it to the end of this meeting. If you feel you don't, then we will continue on.
Is the, what I would like to know is how long is the result of the hearing that how many pages is that? And that if possibly we might be able to read that.
It's,
The
if I had to say, it's
transcript of the
sprinkled
hearing?
throughout.
No, not the transcripts, but the, how it was decided.
It is 71 pages,
I know.
but from a practical standpoint, as far as it's really 68. So, you know, you're 68 in that.
Do the facts and findings cover the judgment of the hearing?
So if I may,
We-
there's a summary, okay, so if I can just kind of describe to you what the consolidated final order is. The consolidated final order is it's the order that was issued by the Florida Department of Environmental Protection approving what the administrative law judge did. And so what you have in this document is their order, and then attached to the back of that is the administrative law judge's order. And you'll see that in a different font than the first several pages. So that's part of why it's so long. You'll see, starting on page 7, a summary of the recommended order. That ends on page 50, or 51, where they begin to start talking about the legal issues. So 70 to page 50 are the factual findings that DEP has adopted from the administrative hearing. And so that is what we would call to your attention in terms of factual issues that have been resolved between the parties and that the applicant believes is binding on the town.
I'm sorry, but does everybody's package start on page 20?
20.
That's what mine starts on. Mine starts on page 20.
Take mine, I've read it.
Which package are you referring to,
This
Jane?
package.
Yeah, hers is missing the first 20 pages of the order.
Madam Chair,
Yes.
and correct me if I'm wrong, and council, please do the same. The matter before this board is the special exemption
Yes.
by the plaintiffs and whether or not they qualify for the special exemption, which is the town's rules.
Yes.
To me, what is in that 71 pages or in this document here doesn't tell me whether or not these guys are qualified or qualify for the special exemption. This is a bunch of legal terminology and findings that a judge in some other court in the state has looked at and agreed with. But what is before us is whether or not they qualify for our exemption. This is what we should be looking at, not what's in this document.
And I agree with you, and I'm fine. I'm just asking those who have not read it if they feel the need to read it, which sounds like you are not needing to read the 71 pages.
Nothing to do with our exemption.
It wa-
Now,
the
it
big
will
piece of-
cover it in
yeah.
this portion, which is the PowerPoint presentation. And that's going to give us their views on why they think they qualify for this exemption.
Correct.
We're also going to hear from our town people to tell us why they don't think it's going to be that way. So whatever's in these documents really has nothing to do with my decision-making.
I'm sorry, I think some pages came out of one of the binders. These are the
That's-
pages you were missing.
Right there. Okay. I am in agreement with Tim on this one. I'm looking to the other two if they're in agreement with me with this on this, because they have not been privy to this. We do know that it was submitted into evidence, and we were provided with the pieces and facts to answer these specific questions on our exceptions.
Let me say it another way, maybe that is, if the recommended order and the final order were dispositive of all the issues, then we wouldn't be here. What the administrative law judge in his recommended order and DEP in accepting that recommended order determined is that the applicant met the requirements under state law for their state permit and for their authorization to use state sovereign lands. But the order very specifically says you still have to go to the town and get their permits. And that's why we're here, is, do they meet the requirements of your code? How they demonstrate compliance with that, through reference to the order, through PowerPoint presentation or whatever, is again for you all to consider and ultimately decide if they've carried their burden and are entitled to the special exception.
I don't disagree with
Don't
what
either.
the council just said. However, and it's true, we have to make a decision as to the meeting the requirements of our code as to the exception. But I don't agree with Tim that this whole thing is irrelevant, because there's a very fascinating history here that we were not aware of, number one, never been brought to our attention. Number two, there are findings here that may or may not bear on the exception, that may be inconsistent with the staff and entitled for us to consider. But that's to be brought out by both the staff and the applicant, and I'm, of course, have my usual open mind on that. But I think that that there's some relevancy to the material.
If I may add to that, and I believe, and I don't want us to mischaracterize Ms. Petrick's statements, but I think that is her comment, is that in her PowerPoint presentation, in her presentation, she will touch upon those provisions of the final order that the applicant believes have relevancy to the standards, and staff will have an opportunity to argue to the extent that they believe that's not the case, and you all will then decide what weight you give to the contradictory evidence and testimony, and as the finders of fact, make a decision.
If I may, before you make this procedural decision, I just want to make clear that the applicant's position is that while the administrative hearing did not resolve your land use issues, it did make factual findings that we are not here to relitigate. The town was a party to that hearing. The town had an opportunity to put on its case about things about birds and about stability of the project and a variety of other things. The ALJ made decisions, and those decisions on those factual points are binding. It's not binding as to how you apply your code, but you cannot base your code decision on a factual finding that is the opposite of what the agency decision was, because you were part of that litigation. And so it's administrative res judicata is what that is.
I am looking to council to see if we're about to step in something here, and that's why I'm very cautious to move here.
Ms. Petrick's statement and the position that she's taking on behalf of her client has been expressed to me, and I've indicated to her and her partner yesterday that conceptually I don't necessarily disagree with it. Still, the fact remains that they have to demonstrate compliance with the criteria. Again, how they get from the application to convincing you all is up to them. I don't again mean to speak for staff. I think that staff probably is in their staff report, as I've read it, say we don't see the issue of the administrative hearing as being necessarily dispositive on some of these factual issues. Again, that will be for you all to decide.
Okay, I am thinking we're moving forward. We're going to go ahead and have the town call. We're going to go ahead with this, and in our discussions, we have options at the end of this to decide what we feel as a board to do. And
I mean,
and make recommendations, not make recommendation to town council at that point.
If after the entire presentation by the parties, and you hear the testimony of the public, you all still feel a need that you have to read the entirety of that order, then so be it.
So at that time, yes.
I have one question for council.
Yes, sir.
This document that was provided us today, is this now an official document of this meeting?
I believe that they are going to, yes, they're going to make it and ask for this board to include it part of the record. That's certainly, to the extent that it has relevancy to the proceeding here today, you can say, yes, we'll accept it as part of the record, or not.
Well-
So I think that let them make their presentation, refer to the document, and then, at the end of their presentation, I, again, don't mean to speak for Ms. Petrick, but I would suspect that she'll then ask you all to move the binder documents into the record and be part of the record for consideration.
At the
That's
end of
fair.
this, if you feel you need to read it,
Well, the only thing I wanted to clarify was the fact that if it's not part of the record, then no, I cannot consider what's in it. I can only consider what I hear here today in this meeting. But if it is part of the record, then yes, everybody here can consider what is in here.
If
That's
she
why I wanted
presents
a
it to us, then-
clarification on whether this was part of the record or not.
okay. First up, so we're going to move forward with this.
Okay.
Okay, first up will be the town to present it to us. Don't go far.
In this particular
It will
instance,
be in the
based
record. They
upon
haven't presented it yet.
the issues, and it's, if it's in your rules, then staff goes first. But I think it would be maybe prudent or better in this particular instance to allow the applicant to make their presentation so you can hear what it is that they're
Is the town
asking
okay with
for.
this?
And then staff will have their opportunity to rebut that and attempt to convince you that that's not the case, as reflected in their staff report.
I thank everybody for their patience during all of this.
Staff, I'm sorry?
Get the TV
turned
on.
on.
Oh,
Technicalities.
Both of them.
Okay, so let's see how, it says it's on.
Got a light.
Okay.
No, there they
All
go.
right, let's see what happens.
All along.
Now you guys are taxing my technological abilities.
Yeah,
Let's see
there you
how this
you're
goes.
taxing everyone's.
What kind of statement was that?
All right, I guess it's just
I'm hearing
warming
we're
up.
taxing everybody.
Appreciate everybody's patience. Distance one for close, because I wore my contacts all day yesterday on the plane and such.
Yay, okay. All right, well, let me first thank the members of the LPA for hearing our application. We're here today on Squeeze Me In and Texas Hold'em's application for a special exception to allow for a proposed dune walkover to be built in between the two addresses of 8150 and 8170 Estero Boulevard. All right, there we go. I'm going to go through this really quickly because this is not an issue where we have any disagreement with the staff. The future land use for these two properties is split between low-density residential and recreation. Those are your future land use categories. And what you see on the screen is an excerpt of your future land use map. Trying to figure out where to, there we go, okay. So the item that you're seeing on the screen right now is an aerial, and so you'll see the two houses, they have the sanded, raked area behind them. In green was the original design of the proposed dune walkover. In brown, what you see is the approved design, and that modified alignment was chosen in consultation with DEP to make sure that this dune walkover remained outside of your critical wildlife area boundaries. And therefore, you have absolute evidence, and in your packet, you have the amended notice of intent to issue the state permits, which also reaffirms that this proposed dune walkover is not within the critical wildlife area. It sounded like there was some information presented to the contrary, but this is an established fact. This just identifies for you the adjacent zoning and land uses, which are generally understood. The only distinction is that the critical wildlife area does not incorporate the entire area that is south of the property or of the project itself. And you can see the boundaries that are depicted within the graphic. Again, this is the survey which was accepted in the administrative hearing, and this survey shows where the critical wildlife area, that identifier in red, and it shows how the boardwalk is deflected outside of the critical wildlife area. In the consolidated final order from DEP, the administrative law judge and the agency made a factual finding that is binding on the town that the proposed dune walkover is outside of the critical wildlife area. And the reason why I'm harping on this so much is because there has been considerable confusion about this issue, and a lot of people have been concerned about the idea that you would be authorizing a structure within your critical wildlife area. That is not what you would be doing here today. So now we're turning to the criteria for the special exception use, as did the staff report. And what you will see is that this PowerPoint largely tracks how the staff report analyzes the criteria for issuance. And the first thing that the staff report started with was the definition for special exceptions. And the first provision of that is that it relates to uses that may not be appropriate generally or without restrictions throughout a zoning district. Well, in fact, your zoning code does authorize dune walkovers in the area that we're talking about here. It very specifically says perpendicular dune walkovers are permitted by right in accordance with, and then there's another section. Now, your staff has chosen to call this a combination of a boardwalk and a dune walkover. The reason for that has never been explained, but they're entitled to do that, and that is something that has been also established. So the agency order has required certain things of us, like we go through this process, and it's required certain things of staff, like they live with factual findings too. And so for the purpose of our application, we are accepting the idea that this is not going to be treated as a perpendicular dune walkover permitted by right. However, as a practical matter, that is what it is. And so the idea that this would be a structure that is not generally appropriate for this area is in conflict with your own zoning code information. Okay, so then the next portion of the special exception use definition talks about uses that can be permitted when controlled as to number, area, location, or relation to the neighborhood that would promote the public health, safety, welfare, order, comfort, convenience, appearance, or prosperity, and that they may be permitted. So I want to focus first on that discussion of controlled as to number, area, and location. And the reason why I'm focusing on this is because there's been a fair amount of concern about the possibility that if this were permitted, that it would open the floodgates for other similar types of structures to be applied for and permitted. And so one of the important factual things that needs to be considered is that this property is unique. And part of why it is unique is because of its relationship to the CWA boundary. The properties that you will see to the left side of the graphic, they are directly across from the CWA boundary. And so, whereas here, you're not permitting a structure in the CWA boundary, for them, you would have to. And so they're not similarly situated to 8150 and 8170. So saying yes to this application does not create precedent for all of those homes. Now, the homes that are to the right of the graphic, they have, as we will discuss in a little bit, they have better access to the beach than 8150 and 8170, and therefore they are not similarly situated to these two homes. Because they are unique, this is not an issue of precedent, and therefore you necessarily are controlled as to number, area, and location of this type of structure. Okay. So I've just told you that the property is unique because of its location, and DEP, in its consolidated final order, made the same finding. The DEP said There are no existing permits or pending applications for similar dune walkovers in the area, given the presence of the CWA. To the west, applications for similar walkovers within its boundaries are unlikely, and if made, would have to comply with critical wildlife area restrictions. So DEP recognized the statement I have just made to you, that this property is unique and that precedent is not a concern in this issue. Okay, so moving on to the next piece of the special exception use definition, where you're talking about public health, safety, welfare, order, comfort, convenience, appearance, or prosperity, DEP again made certain findings that relate to this issue. And the first thing that is important to note is that DEP found that there were public benefits to the existence of this dune walkover. And what they said is, the dune walkover will serve to minimize foot traffic on the native dune vegetation and channel the foot traffic from its terminus to the shore of the Gulf of Mexico. As such, the dune walkover will have a beneficial effect on the native vegetation in its immediate area. Now, in the staff report, the staff has suggested that they either don't believe this or that they think it will harm the vegetation. But this is a factual finding that is binding on the town because town staff made their case in court and the administrative law judge made a finding that the town was a party to. And therefore, this is a fact that you have to live with, just like we have to live with the fact that we had to come here today, even though we thought we were a perpendicular dune walkover permitted by right. Okay. Again, this is another place within the DEP's final order where the DEP has recognized that the walkover will allow access in a much less disruptive and destructive manner. So again, you're another statement from the agency order finding the public benefit of this dune walkover. And then finally, Ms. Mills, who is she is an employee of DEP, and she was part of the permit reviewer. And so this is a quote from the administrative hearing itself that the ALJ found was convincing testimony that the boardwalk in this area would serve to minimize unrestricted and unchanneled foot traffic and direct traffic so that people are not using other manners that aren't specifically defined, causing more adverse impacts through natural and sandy areas. Public benefit. Okay, so the next piece of this special exception consideration is whether there exist changed or changing conditions which make approval of the request appropriate. Now, staff has suggested to you that there have not been changes, but however, that concept or that conclusion is rebutted by the facts that are in the record. And the first piece of this issue is a very practical consideration. Since these two homeowners purchased their home, the access to the beach has substantially changed. And part of the reason for that is because the homes that are circled here in red blocked access to the raked sandy area to the right of the image. And the house that is directly to the left of that red circle didn't exist when they purchased their property. So the practical way that people would access the beach is they would go through that empty lot, cross around the water body, go to the raked beach area. Well, so that house was built, and now these two houses that are circled in red cut off access through the building of a fence and the erection of, or the installation of mangrove plants. And so now these two homes don't have access to the beach except to walk through the lagoon and over the vegetation. And so that is a change that necessitated their building of the dune walkover, and it's the reason why they've spent a couple of years and several thousands of dollars to attempt to restore the beach access that they had when they initially purchased the property.
Could I just ask a quick question on that point?
Yes, sir.
Could you elaborate briefly on why the fence was allowed to be built? What changed that allowed the fence to be built to block access?
Certainly. So Many of you may know that here in the state of Florida, the idea of who has control over what happens to the beach largely depends on where the mean high water line is. And so the idea is that the wet part of the beach is publicly accessible, and then the dry part of the beach is something that the upland landowner can control. Well, and we're going to talk in a minute about how the shoreline has substantially changed in this area. And as the shoreline changed, the idea of where the public access is versus the private access changed too. And so the homeowners that are circled in red here came to the conclusion that they had the ability to cut off that public access because they didn't like people walking behind their house, and because they understood, okay, the mean high water line is on the other side of this this lagoon space, and so we can restrict people's ability to walk behind our house. And so that's why they did that. So following up on that, the other significant change, as we've been talking about, is that the shoreline in this area has changed substantially. On the screen, what you will see is that the administrative law judge, considering what he referred to as Exhibit 43, found that there has been accretion of the shoreline over the last 50 years, and especially within the last 10 to 15 years. And so the shoreline has been accreting at a rate of about 28 feet per year between 1999 and 2011. And you'll see in the bottom of all of these pages where I've quoted the actual page if you're interested in looking at the full passage. And so Exhibit 43, okay, there we go, is actually a town exhibit. It wasn't the homeowners exhibit. This was what the town put into the record at the administrative hearing. The town argued this shoreline is changing at a dramatic rate and is substantially different than it was. So it's interesting that the town staff is now trying to say something different, but at hearing, this is the document that the town submitted. And so on the left, what you see is an image from December of 2003. And on the right, what you see is February of 2017. And in both instances, on the right, it's clear where the raked sandy area begins so that you can orient your focus. On the left, you can still kind of see it. But what you can see by looking at these two documents is that the area in question has changed dramatically in the period of time that these are aerial images. And so the shoreline accretion has changed the mean high water line, like I've just talked about. It also has changed the way the lagoon feature is and how it functions. And so all of this has impacted how these homeowners who purchase their house with an expectation of practical beach access, how they get from their home to the public beach. And that is why we're here today, because that's all they're looking for is some way to access the beach. Okay, so once you determine that a change has occurred that necessitated the application, the second thing you need to think about is whether or not the application meets the comprehensive plan. And so there are a variety of comprehensive plan policies that not only allow, but support, and in some cases mandate, the erection of dune walkovers in order to facilitate beach access. So let's briefly look at those. And each excerpt is reproduced in your binder. So the first one, this should say 4A6. I apologize for the typographical error. But it talks about how beach access is important and should be maintained and expanded where possible. So that's just the general proposition that as a town, you're committed to facilitating beach access. Now, the next one is more specific, and it says under Coastal Management Element Policy 5D1 little double I, that dune walkovers should be constructed where they do not exist, and existing structures should be maintained. And the reason for this is to protect the sand dunes, and the native dune plants should be protected. This is exactly what DEP said when they said channeling and minimizing foot traffic through the lagoon feature and over the sand dune is a public benefit. So DEP's findings and your comp plan are saying the same thing about why dune walkovers are beneficial. The final piece, policy 6E1 of the conservation element, says that for any beachfront development approved after the adoption of this plan and for all public beach areas within the town, state-approved dune walkover structures shall be required at appropriate crossing points. These same structures are also encouraged wherever pedestrians will be crossing dune areas. And in a minute, we're going to see the aerial again of this area, and what you're going to see is that there are pathways that have been kind of dug into the native vegetation because the public does access the beach through this native area. Okay. So staff has indicated that they believe that this application does not comply with your comprehensive plan because staff is saying that it is harmful to the birds that use this particular area for nesting and foraging. However, DEP already made a finding, and the finding was that there are no adverse impacts to the dunes, to the beach, or to the birds as a result of this proposed dune walkover. You see here, the ALJ concluded that the competent, substantial, persuasive evidence demonstrates there will be no adverse impacts to the value of functions provided to any species of concern provided by the lagoon and the associated wetlands. It says later, shorebirds, whether or not they are protected species, will not be impacted by the project. Later, in the opinion, you see here the reference that competent, substantial, and persuasive evidence demonstrates that the proposed dune walkover will not adversely affect the conservation of fish and wildlife, including endangered or threatened species, or their habitats. And so recall that this was a finding that happened after your town staff testified. You had town environmental staff testify. Mr. Green testified. And so this was a finding that was made after your staff said what they had to say on this issue, and therefore it's binding as a factual matter on the town. Now, staff has raised another issue with respect to why they believe that the comprehensive plan policy regarding dune vegetation is not complied with this application. And they have alleged that removal of dune vegetation and stabilization of submerged and exposed beach by artificial means other than replenishment with compatible sand is a prohibited action by the town. Well, initially, it should be noted that that type of activity is more what one would consider to be a hardened seawall or a hardened shoreline. The dune walkover doesn't actually do any of those things. But, and I don't know, I think I might be missing a page. In the final order, part of what the property owners had to demonstrate was that this project would not create erosion or instability within the dune. And the ALJ made a specific finding that was accepted by DEP that there would be no erosion or instability caused to the dune by this particular application. Moreover, the permits require that dune vegetation that is removed will be replaced as part of the construction. So there is not permanent removal of dune vegetation. Okay, so now moving from your comprehensive plan element requirements to now your code requirements. Number 6 of your special exception criteria requires that the request meet or exceed all performance and locational standards set forth for the proposed use. Now, I had indicated to you earlier that perpendicular dune walkovers are permitted by right, and there are a series of locational and performance standards that relate to those dune walkovers. This idea of the The boardwalk dune walkover hybrid that staff keeps calling this project is not actually a thing in your code. It's not actually an identifiable category. So the best I can do to show you what your code allows is to refer to the thing that this really substantively is, which is a perpendicular dune walkover. And what you will see is that all of the land development code requirements are met by this application. So for example, dune walkovers should be perpendicular, which means that they do not deflect more than 30 degrees from the houses that they serve. And if you look at the survey and sketch, which we saw earlier in the PowerPoint, and you have a copy of it in front of you, it does not deflect more than 30 degrees. The walkover should be supported on posts embedded to a sufficient depth to provide stability and not be encased in concrete. The amended notice of intent that you have in front of you will show you 5 foot of embedded poles. This is a pole stabilized walkover, no concrete. Those are requirements of the state permit. Dune walkover is less than 6 feet wide. Yes, it is. This is a 5-foot walkway, and it is specifically 5 feet down from 6 feet because DEP requested and the homeowners agreed to modify their plans to take it down to 5 feet to reduce the footprint. The last piece is that the dune walkover will extend to the seaward toe of existing dune vegetation. That is expressly required in the CCCL permit special condition 6. So continuing with the requirements that are within your code for this kind of thing. The dune walkover will be constructed in a manner that minimizes the short-term disturbance of the dune system. Vegetation damaged will be replaced. Special permit 5, the CCCL permit requires exactly that in almost exactly the same language. The walkover will not be constructed during sea turtle nesting season. Again, a general condition of the permit allowing for this project. The dune walkover is at least 150 feet from the nearest existing walkover in a location where pedestrians need to cross dune vegetation. There is no other similar walkover within 150 feet or even more in this area, as the graphics have shown, and the prior ALJ finding also confirmed. The dune walkovers to be constructed within the riparian extensions of the subject property, the survey reflects that. So this particular dune walkover meets each and every one of your land development code requirements. Now, one of the issues that was raised by the staff was whether or not this kind of dune walkover is allowed in the EC zoning district. The EC zoning district expressly allows for hiking or nature study, including pedestrian boardwalks and dune crossovers. So it's expressly referenced in your EC zoning district, and there is the section that reflects that. The dune walkover has to meet side setbacks, and it does. The dune walkover has to satisfy the prohibition against beach access directly over dune ridges or beach escarpments. That is not at issue here. Okay. So number 7 of your special exception criteria is whether the request will protect, conserve, or preserve environmentally critical areas and natural resources. And again, DEP made the finding that this dune walkover creates benefits for the native dune vegetation in the area. And here is the quote from Mrs. Mills saying that this directs and minimizes foot traffic so that people are not using other manners that aren't specifically defined, causing more adverse impacts through natural and sandy areas. Okay. So here is the quote regarding the dune stability that we talked about a little bit earlier, and what you will see on the consolidated order on page 30, Ms. Mills, who is an expert in the field, she was accepted as an expert by the administrative law judge on this topic, said that piling-supported structures are used in dynamic systems all the time, specifically because they don't really have an effect on the movement of sand. And based on her testimony, the ALJ found, and the agency accepted, the concept that the proposed dune walkover will not cause harmful erosion or shoaling, because dune walkovers don't do that. That's why they're built the way they are on pilings. Similarly, the state actually has a beach and dune walkover guideline that is in your packet, and it tells you how dune walkovers are to be constructed precisely for the purpose of making sure that the dune walkovers are compatible with the beach and dune systems. And you will see here that DEP encourages the design of beach access, including beach and dune walkovers, to protect the dune topography and dune vegetation from pedestrian traffic. And so DEP's guidelines encourage the exact same design that we have proposed here today. And that is further evidence of the fact that this is not a harm to the environment as proposed. Okay, finally, there are a couple of examples of boardwalks that are within your general vicinity, within the EC zoning district, that have been approved and are not causing harm to your beach or dune system. The past preserve that you see here in the image, and then Lynn Hall Memorial Park Dune Walkover. This was a 2019 project that the town just recently approved and has been erected. All right, so just a couple of other statements that were made in the staff report that need some information. The staff has said that in section 34-652D6, that the town's zoning requirements, and this is a quote, so I didn't say stat, that's in the original staff report. I think it's intended to say state, that no land or water use shall be permitted by right, except for those uses and developments permitted by the Fort Myers Beach Comprehensive Plan and so forth. But the staff's quote is incomplete because in D4 of that exact same area of your zoning code, it says hiking or nature study, including pedestrian boardwalks and dune crossovers, are allowed. So I don't know why staff put that in there without letting you know that the dune walkovers and the pedestrian boardwalks are expressly allowed in your EC zoning district, but it is, and you have a copy of that portion of your code in your binder if you want to look at it. Similarly, there was a reference to the dune walkover being a permanent structure and causing alteration of the natural landscape. In that beach and dune walkover guidelines from the state, you will see that the state refers to these structures as minor structures and expendable structures. And the reason for that is they're designed to give way in the event of a major hurricane so that they don't cause harm to the dune. They are actually designed so that they do not alter the dune landscape in the event of a significant weather event. Okay. All right. So the last thing, whether a requested use will be in compliance with applicable general zoning provisions and supplemental regulations, the town staff you see in the box raised the issue that if you allow this, the nearby residents from applying, that it will prevent them from applying for similar structures. Well, as we said, these folks aren't going to be applying for similar structures anyway because they are differently situated. And one thing that I would like to point out for you is, I don't think this guy has a pointer. Let me see, is this a pointer? No. Okay. On this image, you will see little white lines through the vegetation. There are bigger blow-ups of this particular image. Just to confirm for you that people are carving their own paths through
Would you
these.
go point to them?
Sure.
Because I don't even see them on my picture.
Okay. So I'm going to go to one of the bigger versions. All right. So, and I'm just going to walk up to the screen so that I can show you.
Just point to them. Okay, so you're talking out of the back of their houses.
And then here.
To the water line.
And there. They go around the dune. And at the administrative hearing, that was a source of testimony in support of DEP's decision that foot traffic needs to be addressed within this area because they have proof that people are walking through the vegetated space. And I would point out that where those particular paths are carved is actually in the critical wildlife area. Okay. All right. So just for some concluding remarks, parties on both sides of this issue have spent years and thousands of dollars trying to get to the bottom of the facts of this case. You know, people who were concerned about it, they hired experts, they presented their information to an impartial administrative law judge, and that administrative law judge concluded that there is no harm to the resources or to the wildlife in this area resulting from this proposed walkover. And therefore, that should not be a basis of your decision today, because it is a resolved issue that is binding on both the town and the applicant. Your code and your comprehensive plan not only allow, but encourage dune walkovers. That is how your zoning code is built. And the design of this walkover has been substantially amended in order to reduce any perceived harm from the walkover. And just so that you know, now staff did not address this issue, but in point of fact, significant changes, not only to the alignment, which we saw in the first couple of slides, but also to the structure. It was made more narrow from 6 feet to 5 feet. It was reduced in height. Handrails were taken off, and instead of steps, it was made into a ramp. And all of those were changes that were made in order to reduce the footprint, reduce impacts to the resource, and to address how the wildlife uses that area. So for example, the handrails were taken off at the suggestion of people who were concerned that predatory birds would perch on the handrails. And so now this dune walkover is no taller than the town's own signage in this area. And all of those changes were made for the purpose of making sure that this did not have impacts or even perceived impacts. So these homeowners have worked hard to preserve their beach access without impacting their neighbors. And so with that, we would respectfully request that you make a recommendation of approval to the town. And the homeowners are here today if you have any questions for them, and I am happy to field questions as well. I thank you for your time and attention.
Thank you for your time. Town, would you like to? You coming? Jason?
Hey, hold on. Got a lot of paper here. Sorry.
I'm sorry, I meant to. This all the time in hearing. Before we kind of end our case, could I ask for you to receive and file the binder? Now, I have given a binder to Mr. Green, which has all the same material as the binders I provided you. It also has the full transcript of the administrative law trial, so that that information is within the record, because we've referenced it throughout the PowerPoint, and I want to make sure that you have exact wording within your record.
For us, though, I'm going to call the town, and then we'll ask questions. I want to get both sides. Jason?
Are you, they've moved into, they're asking you to accept into the
Yes,
record
we accepted it.
the entire, again, I would just caution you, as I said before, well, I believe it's more than that.
It's actually mine.
They're asking, they're moving into the record the entire transcript of the hearing before the administrative law judge as well. And again, I'm just saying, that's perfectly fine, and you all can accept it, but you know, give it the, I would suggest you in considering it, you give it the weight that it's due, and ultimately that's a decision for you all as to its relevancy of the entire transcript to this particular proceeding.
We're talking the transcript on top of the final judgment order.
And they're moving the binder in its entirety in, and in addition to the binder, the transcript of the administrative hearing before, or a transcript of the hearing before the administrative law judge.
Yes, because I've made representations to you about testimony that was provided. I want to make sure that your record isn't reliant on my characterization, that you actually have the actual words within your record.
And I feel that we need it if she's referenced it.
Yeah, well, it's up to you. I believe that where she referenced was to where the administrative law judge referenced.
Did both.
So either way, it's before you, and you give it whatever weight and credibility you feel appropriate, given the circumstances.
Do we need to motion this?
No,
Or do I
mean,
just need to say accept it?
It's accepted
Okay.
if it's, unless there's an objection.
Objections? Okay. We'll accept it as evidence. Jason, and we'll let you get, in the idea is let you speak, and then we'll ask the questions of both of you.
Sure. And I'll try to go in a similar order. There's some things I think I'm going to move around for you just to address while they're fresh in our mind. I did have an email that we got after the packet was produced that I just want to hand out to. It is a letter, it is email of objection for the record, since we
Please
have
do.
that. And I'll hand it out to you all. Take it for whatever weight you want to give it.
Correct. And, to the extent that the rules of evidence and procedure are relaxed in these types of proceedings, but it goes to the weight, the fact that the witnesses or the individual's not here to be asked questions by either you or, for that matter, the applicant.
Does the applicant have the right to object to that being in because they're not here?
They can ask, but you can, say, accept it.
Just asking.
Yeah, yes. If they wish to object, they can state that for the record.
So, and just technical, I did copy and paste this from the email. Our email system would now allow me to print the actual email with the headers and all that on the top, but we do have that as part of our records in our email system. So, look for your cue
Yeah,
once
here.
everybody has it.
Yes, we all have it.
Okay. And I guess in light of that email, when you read it, and for clarification to what the applicant said, we do, I guess, I don't know if concede's the right word, but their proposal, as they've stated, is not within the CWA, the critical wildlife area. And so if there's any confusion about that, based on the boundaries that have been set by others, their proposal right now is not within that boundary. So I just want to make that clear for the public record. So, because I think this email actually alludes to through, whether that is interpreting the entire lagoon to be that way, but apparently based on the boundaries, it goes through the middle of the lagoon. So I'll just get that on the record there. You are here because a special exception is required, and I think I don't want to beat the dead horse, but I think it sounds like most of you understand that issue. I've heard several statements from the applicant about comp plan and land development code allowing the uses. The town council, if you remember, this issue was appealed to the town council, and the town council did find that this requires a special exception.
Excuse me, did you say appealed?
Correct. There was an original application that was denied because of failure for a special exception, and they appealed that request to the town council, and the town council found that it would require a special exception. And I believe that was appealed and then went to court, and you can correct me if I'm wrong, but I believe that was upheld by the courts that this type of request requires a special exception by our codes.
Again,
I'm confused.
No, let me put it to you this way. There is no doubt, either in any court action and the administrative hearing, that the applicant needs a special exception, and that is why they're here. There has been prior litigation at one point in time where the applicant asserted that they had the right to do this as of right and not subject to the special exception process. And ultimately, our circuit court here locally made a determination that that was not the case, that they do in fact need to obtain that approval. That order was not overturned. And again, in the final order, that is part of the record already, that was in the administrative hearing, there is a statement in there that to the effect that they do need to come and get local approvals before the state approvals will allow them to move forward.
So, Pence, again,
Excuse me. So that's a separate judicial procedure and separate from the administrative hearing.
That is correct.
Yeah. I was not aware. I don't know that we were,
No, I don't.
we were not aware of that either.
Just the order of things, was that the first proceeding then?
Yes,
That required the special exception?
that is correct.
And then the administrative hearing, were we interveners in that? How did that work procedurally?
The, the state made a determination that based upon the criteria and state administrative code, that a permit should be issued to the applicants that are here, the Texas Hold'em and squeeze them.
TCLs
And
and,
squeeze me in, I'm sorry, squeeze me in. The town of Fort Myers Beach, as well as Audubon, Florida, took issue with that and petitioned the Division Administrative Hearing for a formal administrative hearing, and that's what Ms. Petrick was talking about.
So here we are today with a special exception application, as was submitted in your reviewing. I think we all have agreed between the parties of the land use and the zoning that is designated for these properties. Again, 8150 and 8170 East Estero Boulevard. For clarity, those are two separate properties. They're also referred to by legal description, I believe, as Lot 19 and Lot 20. I'm mentioning that partially because we have a lot of properties with dual addresses. These are two individual properties that apparently are proposing to join or have a joint access to this boardwalk, dune walkover, the structure, and I assume by easement or some other means between the two properties. We do refer to boardwalk and dune walkover. The code, the applicant has mentioned a couple times that they're not familiar with this hybrid, yet then they read the section of code that references boardwalks and dune walkovers. If you turn to tab 16 and what they've provided for you, and the next, I think it's the last page, I believe that's DEP documentation. I believe our town has handed out similar documentation in the past for out permitting. There's a picture of a dune walkover. So the reason why we refer to those two different types is because essentially you need something to get to the dune walkover, whether that's a boardwalk or whether that's a bigger extension of a dune walkover. So that's why we refer to both of those terms on our side related to our code. Because again, generally speaking, the dune walkover is the portion of a structure that is going over the dune. The rest of it essentially is a boardwalk. Both of those are here before you for the special exception component. In theory, you could approve one without the other, I suppose. It doesn't help you get over the dune without the dune walkover. And in some cases, but not all, you generally need, in this case specifically, they need that access to the dune walkover. So that's why we explain as both being included to be able to get there.
Clarify of what I was saying. Well, if that's true, what would you consider the Fort Myers Beach fishing pier?
The fishing pier? Well, I'm not familiar with the structure, but it sounds like a fishing pier or a dock of some type.
Well, it's
Talking
over
about pier.
sand, and then it goes over the water.
Again, dune walkovers are pretty specific type of structure. They have certain criteria specific to them. We do not have the same design criteria related to boardwalks. If this entire area is a dune, then that's fine, and they can meet those are technical requirements that they have to make. I'm just trying to explain the reference why we use both, and both terms are used in our code. It was stated that they are not, and that they aren't familiar with the hybrid, and then it was read that both those terms are included. That's why we use those. If somebody wants to call it all a dune walkover, that's fine too. But I don't think the entire thing's a dune system. I'm not the environmentalist, but I just want to explain why, and you hear in the staff report why you read those two terms. We understand they're kind of together. They need them to be together to be able to get to the dune walkover. We get that, but that's why.
boardwalks to the dune, dune walkovers over the dune.
It appears to me by these pictures and my limited understanding of the environmental part is the dune walkover is the portion that goes over the dune. Okay. So part of what we discussed as far as the requirement of special exception, I think it is worth revisiting that definition, that terminology that is in the Land Development Code, and I'll read it for you. Basically, use special exception means a use or certain specified departures from the regulations of this chapter that may not be appropriate generally or without restriction throughout a zoning district, but which, when controlled as to number, area, location, or relation to the neighborhood, would promote the public health, safety, welfare, order, comfort, convenience, appearance, or prosperity, and may be permitted in accordance with all applicable regulations. Their presentation referred to, all properties having the right to do this, and I think that clearly the special exception criteria does not state that. The comprehensive plan does not state that. And furthermore, that's why we're here, for you to make that evaluation of who gets that. I think the important part of all this, and again, I'm not going to line by line in the staff report, but the critical message that we were trying to get across is, at this point, we don't see how this application, as it's presented, provides a public benefit. I heard statements today about the application DEP qualifying it as a public benefit. This is an application by two property owners to have a joint boardwalk that does not benefit anybody else within the public or within the neighborhood. You've heard testimony about access from, I think was pointed out, the pathways, the footpaths by other properties that are adjacent to it. This does not benefit the public and benefit those properties. This is for two property owners solely. And furthermore, you could argue that it would further enhance the damage to the dune system if it continues to allow nobody else to be able to have these access. It restricts and limits anybody else from having an access across this lagoon. Furthermore, I don't believe it is an accurate statement that you cannot have these kind of walkways or dune walkovers in the CWA. I believe the statement is it's a different criteria and different set of circumstances to go through the permitting process, is what the LJ or that finding was. It is not that they were prohibited or restricted, but our regulations would prohibit lots within proximity of being able to have this access. We just believe that in concert with the other examples that were shown, Lynn Hall Park being an example, those dune walkovers are publicly owned properties with funneling essentially public access in a controlled manner. Those have been there numerous years. They came back before you and went through this process, and really the criteria was they've been there. They're meeting all the technical criteria, and they provided additional enhancements to those walkovers to benefit the public and benefit the dune, such as a dune enhancement. They're enhancing the dune, building up the dune, adding vegetation. Those are the criteria that they presented as the public benefit. And so the basis of this really is we don't see that in the application to benefit the public. As far as the comprehensive plan, again, I'll refer to the reference, let's see. I believe it was the quote was Miss Mills testified about being the boardwalk in this area would serve to minimize unrestricted, unchanneled foot traffic. We don't see that as the application. This is an application to benefit two property owners from having to gain access to where they did not have access before. Because they can't get through, because it was private property. Nobody can cross the adjacent properties to the east, I think were pointed out. And again, in their, I think it was slide 14 of their presentation, they showed the red circle that showed the two properties that separate, I believe it's 4 properties that separated their properties from the beach. Somebody put up a fence, somebody put up vegetation, as is their right for as a property owner. That kind of threw a wrench in the general use of that land that people were using other people's backyards.
Jason,
I'm sorry.
quick question on that point. So you don't have any concerns with the issue that sort of precipitated all this, that fence, you think that fence went up legally and did the appropriate permitting and so forth?
Well, I can't comment on the legal part of it. I haven't reviewed a permit for that personally, but you have certain rights with your property to do. If others don't have access easements granted to them, then yes, there's a legal issue there with access, right? The history is it seems like people have been using each other's backyards. Apparently somebody came along and decided they didn't want to do that anymore. But that also speaks to the changing conditions, which we don't believe, staff doesn't believe, somebody using their private rights to put up, whether it's a fence or vegetated buffer, whatever it might be, is a changing condition that justifies something like this application. And part of the reason is the accretion didn't change their distance from the beach. They were still 2 or 3 lots removed from that access. They still had to cross private land that now was getting modified to restrict their access. That's the only change, is that somebody put up a fence. They still were removed from the actual beach. So the accretion didn't change that. If you look at the old aerials that they provided, they were still adjacent to the water, to the lagoon, not to the beach prior to.
My question really is, and it sounds like you've answered it, based upon your look at this,
Right.
you don't have any concerns about that fence being built that precipitated this whole issue? You think that was done legally and appropriately?
People have the right to do certain things with their property within certain zoning districts, and if those were done in compliance with those rights, then we don't necessarily have a problem with it. There's certain permitted rights. I can't speak to those exactly have met all the code requirements, but if they did, then they're allowed to do them. I think what it speaks to is the bigger issue of the area and the community having a need to resolve a long-standing issue, apparently, that there's limited access and means of access, and if we're going to enhance and protect the environment, then maybe a broader discussion should occur about public beach access in that area. And I believe, talking to Public Works, there's not a town-controlled, from my understanding, a town-controlled public access in the near vicinity down there. So perhaps that speaks to the need for that. But again, this application presented to us was for 2 property owners with the discussion of
Clarification
it's-
question,
it's-
gentlemen, right now.
fixing a public access issue. In our review of it, it does not. It solves a access issue for 2 property owners. So I wanted to hit on that. I'm sorry, was there a,
No, I just was
Pause?
saying we're going to do clarification questions, and then we have lots and lots of questions for you guys. I just want to make sure both sides present their case
Sure.
appropriately.
But again, I think in our reading of the comprehensive plan, yes, the comprehensive plan has policies that encourage dune walkovers, essentially in appropriate places. Our opinion is that the context of that is taken, or excuse me, is taken out of context because there's no reason to believe that the town would adopt policies that encourage every property owner from having a dune walkover. There's obviously technical standards, but the language really directs to say, when it's talking about appropriate places, which we've done and encouraged and successfully achieved with dune walkovers at major public beach access points. The town controls some. There are some that are, many of you are familiar with easements that we've dealt with in other cases that are to the benefit of communities or platted subdivisions on the other side of Estero. Those are community-controlled ones, but they also offer opportunity for a substantial amount of people to have access. Those are the types of conditions that my reading of the comprehensive plan is what it's encouraging, not saying that all properties shall have access, just where it's appropriate. So that's essentially the summary of what is the findings in the staff report, that we believe that their reading of the policies in relation to, I don't believe that they've addressed those issues. I know they said they have. They just give a long presentation about that. But our policies, we disagree with that statement about those policies. Some of the environmental factors, I think, I'm not environmentalist, so I don't speak to the birds and all that stuff, but we can have some people speak to that from the town. I'll leave it up to the attorney to tell you which ones to concede those facts. I'll let him leave that up to you. I'm not a lawyer, so I'm not going to pretend to say which ones rule and leave that to your decision. But essentially, I think the applicant actually did a really good job of highlighting the need for something potentially in this area, but that is not what this application does. This application does not solve that issue and does not address the issues that are being attached to it. And that's essentially why we don't find that there's, they have not presented something yet that provides and justifies the need and the use to be approved for this area. And if you have specific questions about the policies like they went over, I'm more than happy to go over that. But again, I think it's a misreading and misinterpretation of the policies and how they apply in this community.
Okay, I'm going to open it up to our questions. I'm going to start down here with Jim, of either the applicant or the town. Yes.
I don't know if you want to allow public hearing portion.
You need to speak into your microphone. I'm getting yelled at.
Yeah, no, because mine went dead. It may be prudent to take the public hearing portion right now. So when you get to your questions, it includes any questions that you may have that not only from the staff and applicant, but from the public as well.
Okay, then I will open up to public comment. Anyone here to speak on behalf or of this applicant, or anyone here to provide public testimony? I'm going to start here and work my way around. Does that work? Come up to the microphone and state your name for the record, please.
My name is Doug Grant, and I've been selling real estate here for over 25 years, particularly beachfronts. And I can tell you, I don't want to date myself, but I was sitting open houses along the 8,000 block way back in the 90s, and I can tell you that that coastline has changed dramatically. In fact, I had the listing on the property that he tore down, put up, and then he put the fence there because everybody used to walk along the waterway there to get to the beach, and now they can't. I see that the walkover would provide significant value to the properties there in the 8,000 block. We have a home that we represent. We sold the same home in the 3,000 block, and we have that same home priced about 15% lower in the 8,000 block, and it hasn't sold yet, so we don't know what the final determination will be, but I think it would be a big boost for the property values down there. And in another life, I lived in Ocean City, New Jersey, and I can tell you we had plenty of dune walkovers there, and I never looked at them as they were a deterrent to the coast or detracted in any way. And I can tell you they did do tremendous, they were an assistance in terms of stopping the dune damage there along the Jersey Shore. So I don't think this would be a detriment in any way. Thank you.
We have questions of the individuals.
That's a procedure question.
Yeah, if you want to ask the questions right now, because it's specific to an issue, or while they're up, you can certainly ask them the question so they don't have to come back at the end.
Question for this particular person?
No.
Okay.
I did, but I think the what his statement speaks for itself.
I'm John Cameron. I live a few houses down from these gentlemen. I want to thank them for doing something that I couldn't possibly have afforded to do, with all of the legal bills and that sort of thing that must have been incurred in attempting to do this. It is a need to have access to the beach for them, for me. I have pictures from the back of my house before that lagoon was there. Nobody cared about dune walkovers then. Now the lagoon's there. In my opinion, there should have been a beach restoration, but finances being what they are for towns and that sort of thing, it was just easier not to do it. Now these guys want to spend their own money and provide themselves their own access. I would like to do the same. So I thoroughly support them and hope you vote for them. Thank you.
Here, real quick.
I have a question.
I do too. You want to go first?
Well, I'll ask you the question I was thinking about asking the other gentleman. In light of what you said, it appear that there would be a benefit to the public other than the two individuals that are applicants in this case. Is that your opinion?
I don't know if that's true or not. They're going to be building.
Or do you consider yourself part of the public?
I consider myself part of the public.
Okay, all right.
If I Big Dan, I know exactly what his question is geared to, and I think that, I'm sorry, and that is potentially the issue that this board may end up struggling with. And I think that maybe at some point, and I don't mean to suggest that the question needs to be asked of the applicant, are they going to provide access to all of the property owners or grant access of all the property owners to the west of their property line to use the walkover, and that they may then also go to the concerns of staff that it's now a public use as opposed to just two individual property owners who then may put up a fence on their side and say no one else. And that's doable. I mean, they have the right to do that unless they state and agree that it's conditioned that everyone else can use it. And I think that's where the issue, and I don't mean to speak for Big Dan, but I think that's where the LPA may be headed.
My questions were somewhat similar, so we'll ask that.
I've got a question for you. How many houses down from these gentlemen do you live?
I'm the third one down.
Okay, so my question to you is, if they allow you, are you okay with people even further down from you cutting through your yard?
Oh, I haven't put up a fence.
You haven't put up a fence yet.
No, I wasn't planning on it.
Okay, that's my question. You'd be
I
okay
have,
with
I
that?
have a fence around a certain portion of my yard. I don't have it down to the water.
Okay. Good. Thank you.
Goes to follow up on what Scott said. You said you were 3 houses down to the right. Does your property back
Actually, to the left.
to the left?
Yeah,
Does your property back up to the EC property?
it does.
So therefore, there's always going to be a buffer between your property and the EC property.
Critical wildlife property.
Critical wildlife.
I'm not sure I understand the question.
Well, I mean, if your property line ends at the start of the critical wildlife property, is there always going to be a buffer there?
I don't think you're allowed to take anything down, right? Any
Not
of the
allowed to put
vegetation.
anything up either.
Yeah.
So there's always going to be a buffer.
I think what he's asking is I think one of your comments said that you're rooting for these guys, and you don't have the money to do it, but you couldn't do it because your property butts up to CWA.
Well, that's true.
Okay.
I wish it didn't, because I think that CWA was created after the storm. And again, I think that was removing some of my rights, but that's a different issue.
Okay.
I think Jason stated, though, that that's not necessarily, according to the town's thought process, that's not necessarily true. It's just a different permitting process, a lot tougher to get one. We had one more over here. Oh,
Thank you.
Thank you, sir.
Thank you, sir.
Oh, good morning, but good morning is not what it is now. So good afternoon, my name is Mark Lowry. I am the General Manager for Distinctive Beach Rentals. We represent the home at 8170 Estero Boulevard as a vacation rental. This home is a 5-star property that receives no return guest. This is solely based on the fact that there is no access to the beach for the people vacationing here at this home. The closest beach access is a 15-minute walk from the house, which guests find unacceptable as they have rented a beachfront home. Some guests are begrudgingly walking through the preserved waters. As we know, this does a considerable amount of damage to the fragile ecosystem by them walking through versus going around the preserve. The boardwalk would help save the preserve. I would ask you that you approve the boardwalk for the health of the Estero Critical Wildlife Preserve and safety for all the guests and residents of this area. Thank you.
I think we have the same question. That property right there.
Correct.
How far from?
That is one of the properties.
How far from the boardwalk? Oh, it is one of the properties?
It is one of the properties, yes, ma'am.
Okay, thank you.
Welcome.
Excuse me, is that the Squeeze Me In? Is that property? Or is that the Texas Hold'em?
Who's-
Mark?
Who does he represent?
The property that he referenced. So that's the Squeeze Me property that you're talking about?
Correct, sir.
Okay, thank you.
Thank you. Next.
Barbara Schrader, and I'm a frequent user of Squeeze Me In, and I wholeheartedly support the proposal for a boardwalk at this location. I see the need for it. And then I'm also going to read a statement from the neighbors 2 houses to the east of Squeeze Me In, as the residents live in Chicago and they could not be here today. It reads, "Please share with the local planning agency that we are in favor of the approval of the boardwalk being discussed at the October 16th, 2019 meeting. Thank you, Kenneth and Jennifer Denth at 8200 Estero Boulevard." Thank you.
Forgive me, just a quick question. The letter that you referenced, has it been agreed to that they would be able to utilize the dune walkover as well?
I think that's a question we're going to have to ask the applicant from earlier. Same.
And do you want the email as well?
Yes, could you give it to them, but could you state the name of the person that, I didn't get the whole name.
It was Kenneth and Jennifer Drenth.
Drake?
Drenth, Drenth.
Forgive me, did you say that they have been, it has been agreed that they would be able to utilize the dune walkover?
That would be a question for.
Not yet.
Explain to
Not
that.
I don't know the answer.
That's
I'll let
the
you know.
million-dollar question.
I mix it up a little bit.
Yeah, she
Come
can't
on.
name for the record, though.
My name is
Fix our
Zach
necks.
Schrader, and I'm also a frequent user of Squeeze Me In, and I 100% approve of the project, and I feel it is also a need for safe beach access for people in that area. I also have an email from another adjacent property owner, Dennis Prock, and I will give you guys a copy as well. It says, "To whom it may concern, I have no objection and support the proposed boardwalk that has been approved by the Florida DEP." And that's Dennis Prock at 8124 Estero Boulevard.
I have a question for you, Zach, if you don't mind. As a person that uses this property, would you be opposed to people crossing through it while you were staying there to use the boardwalk?
I would not be opposed, no.
Okay, thank you.
Any other public comment?
Hello, everyone. My name is Mike Huffman, and I own the property immediately right of, or east of the properties that are applying, and that address is 8180, and I'm 100% for the boardwalk. I think it's good for everyone in that area, and I think it should be the homeowners' rights in that area to be able to access the beach how they once were able to before Mother Nature and man with pumping the entrance out, the dredgings into that area has changed drastically and cut off direct access, and I think that should be able to be done by this boardwalk and support it 100%. And I hope you vote to approve it. Thank you.
Question?
Yes, I do. Sir,
Sir, come back up.
how do you access the beach now?
You have to walk on someone else's property to the right, which is a ways down, and cut through there, and if there's a house built there, that'll be cut off then.
And where do you cross over then to get to the Gulf? Then, do you go through the critical wildlife area?
No.
You go further beyond that?
To the south or east, whichever you want to call it. Yeah.
Okay.
I mean, I have walked through the lagoon, but
Right.
I'd rather not.
No, you're going north. You're walking north to go to the
To
Now
the
you're going
right,
south,
to the
Jim?
right, which I believe
to
is
the right when you're
southeast.
looking at the beach.
If you're looking at the beach, it's to the left, which
Okay,
I
that's-
believe is southeast.
Okay, we're on the same page.
I have the same question for you that I had for him. Seeing as that you own that property, would you have any objections if they decide they want to do it, letting people to the west of you come through to use it?
No.
Okay.
Sir, if I may, have you had any conversations with the petitioner that allows you to use that Dunham walkover as well?
Yes, Kirk and I have talked, and I think that we're in agreement that there's going to be more than just those two addresses that are going to be able to use that.
A formal agreement?
It's not in writing, but verbally, we have the agreement verbally.
Thank you.
Any other public comment? All right, we'll close the public comment section of this and open it up to our questions and discussion here. You want to start down here with Jim? For either?
I actually have a question for both the town and for the petitioner. And I don't want you to have to expose any strategy in the future, but I'm trying to understand the process. If the LPA were to decline the special exception, what is the litigation path for your client going forward? And given the experience that we've already had with the administrative law judge, and the town obviously didn't fare well in that particular case, how will that precedent impact future proceedings for the petitioner, in your opinion? And I'll ask the town the same question.
Certainly. So whatever y'all decide today, we're still entitled to go to the town council. We would obviously do that. That's just a matter of process. I can't tell you what the homeowners would do, but I can tell you what range of option might be available to them, one of which would be to take that decision to the circuit court and ask the circuit court to determine whether or not that decision was appropriate. Other options might be to consider whether or not denying these properties beach access is compensable through a number of causes of action, whether it's inverse condemnation of their riparian rights, Burt J. Harris Act. But I will tell you that these homeowners have been very cautious about how they have approached the town. They want to be good neighbors. They do not want to be litigious. They just want to find a way to access the beach. And I think you've heard their neighbors be very positive, because these are not people who are trying to, kind of brandish the sword of litigation. They're just trying to find a practical solution.
Yeah, please don't misconstrue my question. I wasn't trying to cast any aspersions. I'm just trying to get a sense of what the litigation risk is to the town should this procedure not have an outcome that's favorable for the plaintiffs. I'm just trying to get a sense of the town's litigation risk.
Certainly, and I do think that there are avenues that would be available for exploration to see if their riparian rights have been taken or substantially diminished that would cause the town to have to pay damages for that. And I'm not saying whether or not they would, or even what the order of magnitude would be, but that is an available consideration for the homeowners.
Thank you. And just for the town, I'm curious as to, given the experience with the administrative law judge, how would the next legal proceeding be different for the town should it get to that point? I'm just trying to hypothetically understand our litigation exposure here.
Let me first say, start off with that I would never recommend to this body, particularly since it's advisory in nature, to even consider litigation risk as a consideration. That's a council issue. The council and only the council has authority to direct me to initiate a lawsuit against any property owner. With that said, I see the potential risk of litigation really almost completely on the side of the applicant bringing an action against the town. And the reason for that is if you all recommend approval and the town council agrees with you and issues the special exception, I do not see a scenario where it would be where they would
I totally appreciate
so
that,
if the town council were to based upon your recommendation of denial or whatever, ultimately the town council elects to deny the application, then and the property owner then elects to bring a cause of action of whatever nature against the town, then we would take advantage of the opportunity that's provided by law to meet with the council in private and talk to them about the law and what those risks are and get direction from them.
My question really was I appreciate
how do I see it?
No, and I appreciate the fact that the onus is on the petitioner primarily, but given the experience with the administrative law judge,
they won one and the town's won one.
Okay, all right.
Okay,
so I'm trying to get your legal opinion on this.
And the type of proceeding that likely would be initiated, I don't want to speak for Ms. Petrick and what it is, what's called a writ of cert, which is what the last one was here in circuit court, where the court ruled in favor of the town. It's where the court reviews the actions of this as an advisory body, and then the town council is the decision maker as to whether or not there's competent substantial evidence to support whatever the decision is that ultimately the town council makes. And there's some other criteria, but I would suggest to you that in my experience, on both sides of the podium or the dais, that in some respects the case law it leans toward the government, and it's again the responsibility of the party appealing that decision to demonstrate that the town council did something wrong.
I believe at this level, though, we are more concerned that we dot our i's and cross our t's and follow the procedure appropriately.
Yes, back to my first comment, which is follow the code.
We follow the procedures at this level, and that next piece that you're talking about is council.
Correct.
Agreed. I just thought it would be helpful to get an understanding of not encouraging next steps, but what next steps could be. Second question and last question is, has the petitioner and ask the town this procedurally, how it would work. Has the petitioner considered granting access to the petitioner's neighbors, or at least the within reasonable distance to this dune walkover? And if so, I'd ask the town, how would we offer that as a condition so it could be formally codified before the LPA?
Well, so what I would like to tell you is that historically, the petitioners have been open to the idea of letting the neighbors in the immediate adjacent area use the boardwalk through whether it's a joint access agreement or whatever kind of agreement would be appropriate. And I will tell you that during the administrative hearing process, the parties who contested the state permits were not exactly supportive of that notion. So, just as a matter of history, these owners have tried to do whatever they could to increase the public benefits of this boardwalk, and I think that's still their posture.
Are they willing to put that into a formal agreement with the neighbors? They own the
are.
properties
They
today.
are.
They don't, who knows what's 15 years from now.
No, they are. They are willing to do that.
Into the town, how would we codify that appropriately as a condition if we decided to make that a condition?
You all would state it as a condition, and we would then work, and generally those are either through a written covenant or use agreement. I mean, there's different, call it different ways, but ultimately it's a document that provides for in writing that the adjacent property is subject, the scope. We wouldn't talk about that and come to an agreement, and that would then get recorded in the public record. So it's always there, as someone mentioned. So 3 property owners down the road, it's a matter of public record, and would have to be followed, and that's how it would be generally done.
It would be probably an easement, right? Probably.
So, easement, restricted covenant. I mean,
Right.
We would have to delineate the area, either through a legal description or some other type of reference. But that's certainly something that we would work with the applicant on, and frankly, it's not uncommon in a situation like this.
It's not. There are a number of those easements, although they don't involve boardwalks throughout the whole town, where whole subdivisions on the Cross Sterrel Boulevard have an easement to the beach. But I'd like to just make the comment that as a practical matter, if in fact this is approved and built, won't matter whether there's an agreement or not agreement, it's going to be there, and unless the property owners are sending out there with an armed guard, it's going to be utilized by the people that live in that area.
So, Jason Green, Community Development. To answer your question, I think it's multiple conditions, probably. I don't think it's a simple one line. I think there's other things to take into consideration. But again, most of those to speak to the process. Just off the top of my head, for example, they could all become joint applicants for the next step after this, which is the actual construction documents and permitting of it, in addition to easements to kind of tie it all together, bind those properties together for that purpose, in addition to just easement. Because again, we don't necessarily, as a town, enforce the easements or restrictions that people put on their own property. That may be a step in a way to get there. But again, we would also look for things that allow us to be able to enforce something that you're conditioning.
As a general rule, restricted covenants, by way of example, are generally private party agreements, and there's some case law here in the state of Florida that says that a local government doesn't have the authority to enforce a restricted covenant because it's not a party to that document, which is essentially a private contract. But there are ways, as Mr. Green indicated, where we can attach it, make it as a condition of the approval. So it's tied in, and in some form or fashion, we could write in that the town would have enforcement rights if someone tried to, down the road, tried to preclude access to the individuals or the properties that are benefited by that document.
Thank you.
Yeah, I have a few questions. Other than this email, I haven't heard anybody in here talk that is against it. Has there been any other objections from fellow neighbors against the project?
I do not have.
Would that be, excuse me, I'm not sure that's an appropriate question to ask if they're not present.
I'm sorry, I'm
If they're not here or
Oh, I
submitted.
guess I was just asking if there's been any other emails sent in,
Have-
objections.
I have
As-
given you what I have.
Okay.
what I
As
have
part of the
received.
original lawsuit, though, can we ask, as part of the original lawsuit, was there any testimony against this?
No, the previous lawsuit involving the town, not the administrative law judge proceeding, and before the DOA, as we normally call, was just an appeal. So they had asked for a zoning verification letter. The town staff refused to issue it, saying you have to get a special exception, not a zoning verification letter, before you go to the state, and was the genesis of that lawsuit. As far as the administrative proceedings, or the proceedings before the administrative law judge, I believe Florida Audubon was also a petitioner, a co-petitioner with the town. So that would be it that I'm aware of. I don't believe that any
Are there any neighbors to
any
cover
other
what he's
individual
saying?
property owner either intervened or testified.
Okay.
There were none. There were no witnesses that represented the individual neighbors.
Okay, and then during your presentation, you said it's their only access to the beach. Do you know how close the nearest beach access is to their property?
So my understanding is that it's a 15-minute walk to go out to the Estero Boulevard and then to try and find some path to the raked sandy beach, but even that will be precluded if further development of housing continues, because right now that raked sandy beach is accessed through an area that has not been developed. So if development continues, as it inevitably will, they will effectively be completely precluded from beach access other than to walk through this natural area eventually.
And then I have a question for Jason. Go ahead.
I would beg to differ slightly. And because the testimony before the administrative law judge, which is in the record now, is the petitioners testified that they now walk across the dune, that there's a pathway. So they would continue to conceivably use that because it's established. What they're saying is that they would stop doing that in lieu of the boardwalk if they don't continue, because then they would have to go around. So there was testimony presented that people now use a pathway to get from the uplands, including the applicants, to the beach. And in fact, there was testimony in the record where I think they were talking about that they pull their kayak through the lagoon area because it's kind of convenient because it floats as opposed to having to carry it and hike it over, so to speak.
I'm sorry, if I could just clarify, the pathway that you're talking about requires them to trespass across a number of properties, and so that is why I said if they are not able to gain access to the raked beach area, then they have to walk through the natural area. So that's the testimony of the applicants, both at DOA and here.
So can I just add on to that, just separate kind of line of conversation? I think the redevelopment, just as a point, does not preclude future access. And actually the comp plan, that's what it's talking about, is beach accesses shall be directed to and encouraged with new development. And so as properties, just as a general concept, as properties go from a single family to resort or multifamily or redevelop into other things, those are opportunities for the town through review to gain other public access, which we've done. That's come before you, this board and the council, have several times in my tenure here have actually ended up conditioning public access through property. So I don't want it to be left that future new development along this corridor is going to preclude that. There is opportunities for them to go through that process. But again, all the technical requirements and location and all that matters. So yes, currently right now there may be limited because of private land, but there is future opportunities. I didn't want it to be left that there's no future opportunity because of new development.
My question to you, Jason, is one of the town or one of the staff's hangups on this is the term public benefit. what, I guess the easiest way I can ask is, what is the threshold to be considered as public benefit? Is it 2 houses, 3 houses, the entire island? Because I think they've stated that they're willing to allow, and that's to be determined as who can use it and who can't, but under public benefits, where does that fall in staff size?
So it's not defined 5, 6, 8, whatever that number is. It's a great question because that's, I think you and the council have struggled with that on other projects, but I think the answer is it's a case-by-case basis. And I think the situational, how many lots are within proximity to each other, what is the proximity to the nearest beach access point that's reasonably accessible, those things matter. So, ease of access, again, you don't want to include properties that aren't going to be able to get access, but we have many easements that include people across the street. So there's not a specific definition necessarily of the number, if that's what you're looking for, or the intensity of access. I think you have to find what you feel is appropriate for that neighborhood, case by case.
If I may add, to Little Dan from Big Dan, there are other aspects of public benefit other than the other property owners utilizing this boardwalk. I mean, the benefit that if they allow other property owners to use it, that benefit is you may consider a public benefit, but there are other issues involved that, in my view, relate itself to the issue of public benefit as well, and that is the effect on the vegetation and the wildlife and so forth. I'm just raising that's not the sole issue that we need to look at in terms of public benefit.
If I may direct you to, in the binder you have before you, 1, 2, 3, 6, 7th page in, at the bottom of it, it says the reference to the order, the consolidated order says 37, so know you're on the right slide, on the slide, the PowerPoint presentation.
Oh, okay.
47?
It says on the bottom of the page 37. And the reason why I direct you to that is that's where, and it's in other parts of the slide, there's the definition of what the special exception is. That's your guidepost. Special exception when controlled as to number, area, location, or relation to the neighborhood would promote the public health, safety, welfare, order, comfort, convenience, appearance, or prosperity, and may be permitted. So that's your benchmarks.
And we would agree with Dan, again, Big Dan's assessment, I guess, because again, under policy, comprehensive 6B5, I believe it is, it references, again, public benefits, looking at those types of things when it's adjacent to the CWA and that sort of thing. So again, it's not just necessarily the use of it. Location matters, right? Does it, you have to weigh the number of users versus does it impact the public use or the public benefit of the thing that it's going across, right? So in this case, lagoon, the dunes, the beach, you got to weigh those against each other. So in one case, you might have 200 homes being able to be accessed. That sounds great. But if it blows through an area that people are using for boating and kayaking and that sort of thing and impacts that, you've got to weigh those issues. In this case, obviously, it's the limited number that you have, but is that sufficient for what the impacts are?
Just 2 more and then I'll be done, I promise. It says here that if this is approved and built, the neighbors to the east, if they're within 150 feet, would no longer be allowed to do the same or similar structure, correct?
Process, right? So, correct, in theory. The technical standards are, they could also apply for a special exception. They can apply for a deviation to that restriction. There is a process that, they have due process rights. But generally speaking, we follow by the code, and we've strongly encouraged that. We were pretty hard on Lee County for the separation criteria and making sure they met it to a T. So we've been consistent in making sure they meet those. But yes, and there is a process that they could come and ask for relief from that. Whether they could justify that again through their application, that's another matter.
And then my last question is about the construction of it. It says that there's going to be no concrete used and there'll be pilings. How far down do those go?
5 feet,
5 feet from the top of the sand?
correct.
Okay.
And that's consistent with the state dune walkover guideline criteria.
That's all I have.
Okay, on packet page, 32, yes, yes, I think 32. and
Wait, Jane, 57 of what?
Of the packet page, it's the pictures of the properties, the surveys,
Okay.
basically. Site plan, dune walkover.
Yep.
Exhibit 52B, and I guess it's still 52B. But my question is, there's a dotted line on one out in the water and a solid line on the other. What are those lines?
So you have, on the site, and you guys can correct me if I'm wrong, I believe those dotted lines are reference to the shoreline of the two lagoon areas,
No,
basically, correct?
the furthest out,
That's
towards
there's like
the
two water
island in the
sections, I
water,
think, right? There's two
or the
lagoon sections,
lagoon,
I
or
think that's what
whatever,
those
in the lagoon.
are referencing. Yes, and then, so in the middle, I believe in the middle of that, you see kind of, let's go to the top towards lot 19, if you're looking at that one. Is that packet 59?
I'm talking about this one out here, this dotted one on this line, and it's solid on this one.
So in the middle, you see pond. I believe that those dotted lines are referring to the approximate shoreline or mean high water line of some type
There can't be two,
of the water bodies?
it's out in the water. It's the one that's
Correct.
out in this box out here.
Yep.
It's a dotted one here, and it's a solid one here. Yeah.
May I approach, just so
Sure.
I can see what you're pointing at?
Did you bring a magnifying glass?
I know, that's why I'm asking, because I just would like verification of the question. Okay, so this is a dotted line here.
This is not, I'm sorry, this is not in the water. This is where the mangrove is, and then this is where the beach is, and this is pond.
Okay, my question is, okay, so they're the same line, one is just dotted, one is solid. My question is, what do the property owners own to?
Yes, that's a good question.
So, and the staff report identifies that they own the platted lots. They own 19 and 20. So if you,
In the water. In the water, how,
well,
do they go past the green area that's on their property and go into the water? Do they have riparian rights on the other side?
Well, that's a matter of dispute that the parties did not litigate, and the owners have not litigated to date because it has impacts on the continued viability of the critical wildlife area. If the owners file a lawsuit to quiet title in the area that is beachward of their property, then that has precedential implications for the critical wildlife area. And so they have chosen not to go there unless they have to, because they're trying to be good neighbors and they're not trying to jeopardize the critical wildlife area.
Okay, so my question is, basically, along most of this beach, on Fort Myers Beach, there is a mean high tide water line that is where people have to be so far back to have either commercial businesses or it has to be open to the public. This area does not have that.
It does. I can show you on the document.
so Jane, the lot, do you see the last dotted line that carries
Over
through
here.
the entire sheet?
So these properties that, in my opinion, from this picture, where the beautiful white sand hits the red arrow, this is not their beachfront, this is. The mean high tide water line is out here.
Their platted property line is back closer to the beach that you mentioned with the red line, their
So
property.
this line right here these people own this property all the way out?
No.
Over the island, over the water,
Well,
to the
I
beach?
mean,
dispute,
the
that's
plat,
what you're saying.
the platted lot, dotted lot is the dotted line. That's closer to what you showed in the picture is the white beach that's on their property.
That helps me, thank you.
Okay.
Which doesn't answer the question of whether or not they own that. That is a matter that is in dispute, and the property owners believe they own it to the mean high water line.
Okay,
That issue. So we're all clear, that was they've obtained the required state approvals to get down to the beach with this. That was the whole purpose of that litigation. So where the property ends or doesn't is really not before you all.
well, it is, because then every single person has a right to having a fence that goes all the way down to the water.
No.
On that side.
No, they don't. The state asserts ownership over that area.
Well, and to add to that, even
Now-
if it was privately owned property, there's restrictions by zoning of what types of structures and uses could go in there, which then you come back, we have this process.
Okay,
Mr. Chairman,
And
a question for whomever can answer it. There is part of, this boardwalk then will not be totally on the applicant's property. Is that correct?
It will be on the applicant's property. The question is whether or not, when it goes over the water of the lagoon, whether it's going over sovereign submerged land.
Well, that's
And-
my point. I
And we
mean,
have an agreement with the state that we can do that. That was the permit.
I know that part of it will be on there, but there will be part of this boardwalk that will be over sovereign property.
Well, we don't agree that it's sovereign, but we agreed to apply for the authorization, which we have received from the state, so that we don't have to litigate that issue.
yeah, the permits have
already
been
been
issued for
decided.
that. That's not before you.
No, but we're,
So the state has issued them the appropriate and proper approvals to do that over this area.
I understand that, but what I'm leading up to is if they do not have legal title to the property, they can't grant an easement to people. I mean, the public has the right to utilize that.
That's why we would be saying that
only if they have access to the land
we-
that they're going to start the walk on.
Yeah, except, they could slosh out into the lagoon and then get onto the boardwalk. And
Well,
but-
I'm sorry, if I could just clarify, the authorization we received from the state includes a lease over that area. So we have a property interest that was granted to us by the state through the permitting process for the entire length of the boardwalk. So we do have a property interest in the entire length of the boardwalk that would allow a condition of shared access. And the state was fine with shared access. It was the town and the Audubon that was initially hostile to the idea.
And I think to clarify is the lateral access of the neighbors would be along their area within their lots.
Right, thank you. That answers that for me, I
If
believe.
you can look on the site plan and see that their proposed location of this ties into their platted lot, so it does come onto their property. Well, the platted lot line, I should say.
Jane, anything else? Okay. Scott?
I think the million-dollar question is how many neighbors are you going to let use this place, or is that still up in the air?
Well, so far it was not identified as something that the town would entertain, and so I don't think that the homeowners have, a defined limitation on it. I don't believe that, the general public would be something that they would be amenable to, but those who have similarly situated restricted access, I do believe that they would be amenable to sharing this resource with them.
Everybody else says.
Dan?
Well, I don't have any questions. I just have a comment that, having been involved in the drafting of the comp plan, and also that provision of the land development code, I wish I had been aware of that other litigation and I understand that was a certiorari.
Yes.
And
Yes,
so
sir.
it was a non-evidentiary proceeding. And I didn't know about that because I had trouble with even hearing this in light of the fact that our zoning code apparently gives them a right to have a walkover permitted by right, but apparently that's been ruled on by the
Correct.
circuit court.
It is by special exception, otherwise we wouldn't be here.
But, okay, so getting beyond that then, I do find, and I personally find that they have met the exceptions.
I've got one clarification for the town, and that is on 5D1 little double I. Sand dunes should be protected and recreated.
Page number?
For our packet number 12 at the top here, because I think that this is where this kind of comes, it was a little unclear because it's been presented in two different ways today to us. Native dune plants should be protected, non-native exotics removed. Dune walkovers should be constructed where they do not exist, and existing structures should be maintained. Question to the town is, are you referring in there, is your interpretation that that is of vegetation, or is that of specifically of physical dunes already in existence? Because you read it to me earlier to make it sound, the town sound, that it was related to vegetation, meaning that this couldn't go there because the vegetation is there. They made it sound as if there's no dune there, no dune walkover there, so hence they could have the dune walkover. So this is a little bit of a,
I think
where did the comma fall?
what the applicant has stated is, somebody correct me if I'm wrong, please, is that the previous ALJ decision, that what their argument is that it found that there is no impact, is that correct, from at the location of what is being proposed? The policy is still there, right, to consider as far as does it. I think they're saying that the previous review of this shows that that location doesn't have the impact.
So if you look at tab, I have it as tab 9, you will see the entire policy page laid out for you.
Tab 9 in here?
Yes, ma'am. And so it says dune walkovers should be constructed where they do not exist, and existing structures should be maintained. So that statement is specific to dune walkovers. It is not sand dunes or native dune plants.
Because a reading from the town made it sound as if they were referring to vegetation right in that piece of policy, which there is vegetation there. And it is both of your opinions that this is in reference to the physical dune walkover.
Sentence reads.
It depends on where you put the comma, or where you put the emphasis.
Well, I think she said that's related to that policy was related to the dune walkovers, right?
Okay.
Let me say this. The request for dune walk, because you're right, we're delineating dune walkover and boardwalk at this point, but there's still environmental considerations for all of it. You can't exclude all that. Maybe that policy related to dune walkover specifically doesn't apply to a boardwalk, but there's still impacts to consider when you're reviewing all of that. So I would concede yes, if it says dune walkover, it refers to the dune walkover portion.
Because your response says this policy states that dune walkovers should be constructed where native and dune plants don't exist. It's the very next line on page 12
Page 12.
in our packet.
Which paragraph? Again, remember, it's a
3.
composite of staff.
First line of 3.
Right, so environmental staff included. There's other staff that contribute to this, so I don't have, which one? You said line?
Paragraph
Okay, here
3,
it is.
line 1. Direct reference to 5D1.
Right, so,
I.
do you have that, Chad? Do you have that? Yeah. So the towns, the 5D1, two little I, I think there's, it depends on the interpretation of whether that's an absolute, right? That's what it comes down to, because it says dune walkovers should be constructed where they do not exist, and existing structures should be maintained. But it also talks about protection of the native. Now, that's where it's kind of open-ended, I guess, a little bit, is how do you protect the vegetation? Is it Some applications have proposed to enhance and add more vegetation in other areas. But ideally, yes, you would want the dune walkover where there isn't any impacts, but then it becomes a judgment call of the rest of it, if there are impacts. And I believe they do have some unavoidable impacts that they've got as included in their permit for DEP, but it's, I'm not sure what the number is. It seemed pretty small.
If I just may, from the applicant's perspective, the entire reason why that policy reads the way it does is because dune walkovers exist to protect native dune plants. The reason why you want a walkover is so you're not trampling on the plants. So that's why those two concepts are linked in that policy.
So as I said, many times when they do a dune walkover, when somebody does a dune walkover, they also enhance and expand the existing dune or return it to a natural state or do additional plantings or other things to further enhance that area.
And if I just may, we haven't talked about this issue because I don't know that it's directly related to the land use issue, but you should know that as part of this state permitting process, the owners purchased mitigation credit for herbaceous plants in the local mitigation bank. So that was also part of the application that was approved.
If I may, to Mr. Green's comment just a moment ago, and to Mr. Petrick as well, is that you may recall that when you approved the dune walkover for the county project, one of the conditions was that they had to put back in some vegetation and restore some of the dune that had otherwise been impacted by foot traffic in that area, and that was one of the things that the county had committed to.
Is the applicant committed to doing the same thing? I don't remember from your presentation.
As I mentioned, the permit itself requires that if any dune plants are impacted by the construction itself, they are required to restore the plants that are impacted during the construction process. So that's already a permit requirement.
God, I don't even know what page it is, because these aren't slide. God, says continued 6, whether the request meets or exceeds all performance and local standards. I'm feeling it's a little stretch to call this hiking or nature study. Can you explain a little bit more as to why use that as a response to this, that there is hiking and nature study happening on this boardwalk, dune walkover?
That is the category that references either pedestrian boardwalks or dune crossovers, and so we gave you the full quote from this section. So that EC zoning district allows for pedestrian boardwalks or dune crossovers as support for hiking or nature study. That's how it's articulated, but those are the structures that are expressly allowed for in the EC zoning district.
Traffic, I get it, but I'm just, I think it's a little bit of a stretch, but, okay, I think I'm done. Let me go.
No, I mean, if I can, I mean, we disagree
These
with
are
that point.
responses
That's why
to
you're here.
why they want a special exception, and so these need to be,
Right.
I feel, need to be brought out a little bit more, because these are the responses to our requirements for the special exception.
Right. So that point you just made, though, I think it's not applicable, right? Because we're here, it requires a special exception. It's not a permitted by right, and it's not that use that they've asked for. Someone could argue Matanzas Pass and public lands that are used for the educational opportunities, they may fall under that category.
Well, questions I have. Anybody have any follow-up questions, anything that they would like to ask of either the applicant or the town? Good. Do I hear a motion? Find it in here.
It's not, because he denied it, so it's not.
So at this point, this is a motion to approve or deny.
So
we know
remember,
we have to do a motion as to whether to deny the denial.
No, you would either.
Motion to
You would
approve.
either do a recommendation of denial based on presentation, facts, not conforming or complying with section, whatever that section number is, 80, wherever it went, 8844, whatever, 3488, or a recommendation of approval based on the information provided to you, the facts, and compliance with that section, and then any other conditions that you may want to do.
I'd have it written down. Okay, so,
No, there have not been any proposed conditions, if that's what you're looking for.
yeah, that's what I was looking for.
But generally, you reference the 3488 criteria, consistency with the special exception criteria, or considerations, excuse me.
Okay. All right. Page 45, if I'm correct here. You want to put the motion? Do I hear a motion?
Were you going to make a motion?
Go for the motion.
I will-
Go for the
If you don't, I'm ready to.
Okay, I'd like to move to approve the special exception, section 34-88, with feeling that they have met the conditions and findings and criteria, and that I would recommend additional conclusions, I guess, that would be, no.
Conditions.
Conditions to be added, that an agreement of some sort be made with the contiguous neighbors along the protected area to allow use, to make it public. I feel that having I don't need to put that in there. Number 2, that they would put back in or restore any vegetations that are harmed in the process. That the reduction from 6 foot to 5 feet is a public benefit also, and the removing of all of the railings. And let's see, I guess that's the end of my.
Does the attorney have something to add?
No, staff has maybe a suggested modification to the conditions.
Shorter, huh?
So, I didn't think you discussed the width. The land development code requires for the single-family access to be 4 feet.
Oh,
Okay, so they have apparently in presentation proposed a 5. There is not a requested deviation to that. I think they've been permitted for 5, but it's only allowed by code for 4.
And the code allows for multifamily for 5, and because this is multiple single families, that is why they've applied for 5.
That's, I don't know necessarily was the interpretation of multifamily in this case.
it's a
I'm
single
gonna have to ask-
family
Well,
on
Camp-
one side and a multifamily on the
We-
other.
I didn't bring that
We
up
can
right
ma-
away because
we
it's
can-
technical, but
We can make it either under, I mean,
We can allow for the 5
we can
feet.
allow it under our, can't we, discretion as a condition for the town council to consider?
I think that's a
does it-
deviation that has not been requested.
Yeah.
Well, and we had to have a deviation for the park to be
We had
a
both of
certain width to have coming and going traffic.
Correct.
Handicap accessibility would be 4 feet?
5.
It would be 5?
That's why it's 5, because they anticipate needing the handicap
But our
accessibility.
docks are 4 feet.
And-
Our docks on the back bay are 4 feet. Our
There's
docks on-
testimony in the DOA transcript about 5 being needed for handicap accessibility.
Well,
just so you know.
here's the bigger question for our attorney, though, for procedure. Do we have to, because that requires a deviation, not a special exception. The special exception is what we're seeing today.
Yes.
Those are two different, two different verbs.
And in fact, I remember that procedurally, with the county ones, we had the same issue where they brought the special exception forward first and then came back and actually there was a
Right.
decision made to continue the hearing, if I remember correctly.
Right.
And they then brought back
Back
the
the-
following month, the deviation request at the same time. So they were approved jointly. So to the extent that that's what the applicant is asking and this board or the LPA is inclined to do that, I would say that it's subject to them submitting an application for a deviation.
So I could
And so
either make
it would
for-
halt, it won't move forward to the town council until you then next month conceivably then process the deviation.
But
Why
if
wasn't
I,
it, why wasn't this
Why
called?
wasn't that in our,
Yeah, why
in
was
the,
this
why wasn't that included then? I mean, if,
well-
they were asking for that.
Well, they have to submit the paperwork for it.
No one has ever suggested we needed a deviation
Well, isn't
for
it
that.
up to the staff to explain to them what they have to
That's-
submit?
so if I put in 4 feet,
No, you
And-
can't, that's what we're saying, you can't, you this is
Have to go with
deviation,
what
it's not
they're-
a special
Well,
exception.
let me, procedurally, if you want to move this forward and the applicant agrees to move it forward to the town council, it can only move forward with a recommendation of 4 because a deviation is not properly before you.
The applicant has advised that they will accept 4 feet in the interest of
Moving it forward?
Yes.
okay, I will change my motion to be 4 feet, a reduction from 6 feet to 4 feet, and that's my motion.
I would second that motion, but with the exception of on condition 1, which you made reference to an agreement with contiguous property owners. The way that you worded that, I think
Oh, it only
it is
goes
too
to-
ambiguous. I
Okay.
mean, it leaves a, how many property owners? And, I
Oh, I don't want to put in,
well, what I'm suggesting is that in lieu of the way you worded it, to say that a condition is that, that the applicant, when appearing before, this matter appears before the town council,
I'm with a,
presents to them a plan for
okay,
some sort of an agreement with the property owners and would be specific as to which property owners would be included, because just to say
Yeah.
agreement with property owners
Right.
doesn't help anybody unless
well,
we
and
know.
I didn't want to open it up to a radius, because that would include
Well,
the neighborhood behind and on and on.
Right, I don't think we're capable of doing that, and I don't think the owners should be put in that position trying to decide that today.
Right, I agree. Okay, so
So-
an agreement presenting neighbor access to the town
Or joint
council.
access
Joint
amongst
access amongst neighbors
No, that's fine.
on the Gulf side.
Conditions 4 feet.
Does that help? Okay.
You can be very specific on it, yes. Do we need to put in anything in there for,
Does that work for you,
Well,
this
yes.
second person?
And I'm going back very quickly to the aerial photograph that's in your PowerPoint presentation. There's to the west of the property, there is probably about 6 slots over. I'm going just off of memory. There's a undeveloped lot that currently impedes any further, the testimony
can't
was
agree
that
to
there is a beach access point further to the west. So, but there's a physical barrier because of that undeveloped lot. It's completely overgrown all the way to the edge of the lagoon. So I would suggest maybe it's anything east of that would be the appropriate neighborhood for consideration. Is that?
1, 2, 3, 4 houses to the vacant lot to the left, looking back at the Estero Boulevard, and 2 to the right, or are you not? Yeah, 2 to the right, because they don't have access because of the fence.
Which house has a fence? The
This
green one or
right
the blue
here,
one?
The green one. Is
You
that
know,
right? The
maybe-
green one has a fence?
Maybe 7 lots to the west, which would include the one that is currently
Vacant?
vacant, if they were to come forward at some point and do it. And then there's another one on the other side that's also vacant, and just let's pick that as the one where we stop.
Is that agreeable?
Agreed.
Okay. 7 houses to the left, 2 houses to the right, looking at a sterile boulevard from the Gulf front. Is the seconder okay with that?
Well, I think we either have to be definite or, yes, I would be okay with that, and add into the, let's see what they're talking about.
No, they include that.
Is there a fence
I would
on
like.
the other side of the 7?
I'm sorry. I'm sorry. It looks like from the larger aerial that's in the maybe 3 lots to the east that don't have access because it's that 4th home that has put up the
Fence.
fence and the.
They already got a fence there, so.
And they don't have an issue because they're already at dry sand.
Okay,
Right.
but does the green one have a fence on the left side of it as you're looking at a sterile boulevard? Looking from the beach to the green one also has a fence.
It would appear, but I don't know where they get
That's
their
why
access.
I'm asking the public here.
Looks like to the left of that green roofed house, there's
It does look like
full-grown
there's
through there.
a full-grown, it may just be vegetation. But the lock-off fence to the sand is at the white house or at the greenhouse?
From this picture, it doesn't look like you can access that backyard of that green roofed house because of all that vegetation.
At this point, I would tell them to get as many approval.
To include any,
We've figured it out.
Okay.
5 lots to the left, which would include the
1, 2,
undeveloped,
3,
because
4,
everyone past that point goes to the west already.
okay,
And 2 to the right, because the greenhouse, which you all have mentioned, they access, if you see there, to their right, there's a
okay.
little open area where that's to the white
Okay.
sand. You'll see there, they have a little walkway there.
So I'll change that to 5 to the left, 2 to the right. That was a,
Just for clarification, can I ask, when you're talking about agreement, these homeowners can make the opportunity available, but they obviously can't make a third party do anything. So
Correct.
it's make it available to the homes, is that right?
yes.
All right, thank you.
Yeah.
I think the big concern is we still want to maintain a public feel to this for those areas. Also, because you are using public benefit as to a means to get this special exception, the public can't just be those 2.
We understand, and we want to make that opportunity available, absolutely.
Is it possible of council that in that agreement, well, first of all, I want you to include in the motion or in our recommendation that this agreement is subject to approval of our town attorney. That's some sort of
Okay.
agreement that's pertinent to the properties. Would it be possible to include in that agreement that people, if they do in fact execute that agreement, agree not to seek a request from the town for a boardwalk on their property?
I mean, if they're willing to forego that right,
Yes.
I mean, everyone has the ability to pursue it. In fact, that's one of the issues where in the final order from the administrative hearing, there is discussion like, well, you can apply, but you are at that point in time going through the CWA, and a whole set of much more restricted criteria apply. So,
The other thing I would say with doing that is that the sands change, and at some point, this walkover may not be necessary like the fishing pier at Leonardo Arms.
Right.
But to say forevermore, they may all be on the sand, and this will be a mute thing, but they all may be behind a bigger lagoon. So who knows?
I mean, one can't predict the future. We can explore that. We can look into that.
Yeah.
I'm not putting that request that they can't do it on there. If the town council wants to.
I think that you just simply, just at this point, we make reference to the lots that been identified, that there'll be an agreement that satisfactory to the town attorney and that included in as a condition to our recommendation.
We understand your concerns.
Want
Is
to,
the first and a second in agreement with their new
Yes.
changes?
Yes.
I just have a quick question. Because it's a two-property application, do we want to use the actual addresses when we're saying to the left, 4 to the left, 5 to the left, and to the right?
We'll refer to the lot, yeah.
Property in
We'll
question.
Provide
Just
the
wanted to make
agreement
sure.
will have a description of the properties that receive the benefit.
Okay.
And there is a formal agreement between those two for this particular boardwalk?
Yeah, they're co-applicants.
Okay. Is first and second fine with their motion? All in favor, say aye.
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 All opposed, say nay. Motion passes. 6, 7 to nothing.
Okay.
We are going to take a 10-minute break. We'll be back in here, we'll re-adjourn at 1:55.
Maybe for the attorneys, so that you know that you don't.
It's just me.
Yeah.
I've lost my
said
agenda
they
in
ran
the
out of-
500 pages of paper.
I can't find mine either.
Thank you. All right, so item number 3, the 200 Street rezoning RC to RPD. Pre-disaster build back is being moved to number 2, and the short-term rentals will be moved to number 3. So we're opening the public hearing up for the 200 Pearl Street rezoning.
Good morning, Sarah Probst with Community Development. Alexis Crespo, agent for Barbara Salemi, owner of 200 Pearl Street, is seeking to rezone the property from residential conservation to residential plan development with a master concept plan. The property is mixed residential on the future land use maps, which is intended to allow a mix of residential and less intense commercial uses. According to the lead property appraiser, the property contains 4 apartment units and was built in 1946. The applicant is seeking the rezoning through the pre-disaster build-back policy and is requesting a 2-dwelling structure. The RPD includes a request for 1 deviation to section 34-3237-4 to increase the square footage of the structure to allow 2 1,500 square foot dwelling units within a single structure. The pre-disaster build-back policy allows the current legally existing density to be replaced on the site up to the original square footage and in compliance with all other aspects of the current LDC. Staff recommends that the LPA recommend approval of the rezoning request with the attached conditions, which include an increase in the side setbacks from 7.5 to 8 feet, a decrease in the site impervious surface from 67% to 60%, and no fill on the site, as well as a requirement to keep native trees where possible and remove invasive species and to maintain a minimum of 3 trees on the site. 2 nearby property owners have come into the office to ask questions about the case, and the applicant is also available for questions.
Does anyone have any ex parte communication on this? Tim, Scott?
No.
Dan? Dan?
Drive by.
Drive by?
No.
No. Okay. Does the applicant have anything to present for us?
Afternoon, Alexis Crespo with Waldrop Engineering. I'm representing the property owners Barbara Salemi and Eric Hoffman. I do have a brief PowerPoint presentation to walk you through if you'd like. I know you've had a long day already.
No, that's fine.
Been out of yard work. This is awesome.
All right, so we're experiencing some technical difficulties.
I'm like, am I moving that mouse?
You're asking something of Patty.
Okay.
There we go.
So I want to start by thanking your staff, who's always wonderful to work with. This is the second pre-disaster build back that our firm has done within the town. We did one back in 2012, and we just think this is a great policy program format that you all have to help rebuild antiquated structures and get some good redevelopment going within the realm of the comp plan, and while expecting enhancements from the property owners as part of the process. As Sarah noted, it's a relatively small property, 5,600 square feet. We are requesting to rezone from the RC zoning district to a residential plan development. We are required to do the plan development when undergoing your pre-disaster build back program in order to allow conditions to be tied to the specifics of the request. And we're looking to redevelop that existing structure with a 2-unit probably what would be a condominium, one for Eric and one for Barbara within the structure. The subject property is located on Pearl Street, just a 1/4 mile from Estero Boulevard, less than 1/2 mile from the Sky Bridge in the mixed residential future land use. And this neighborhood, it does predominantly contain single-family detached structures, but there are also 2-family and multifamily in the area as well. A photograph of the existing structure on site. It was built in 1946, not built obviously to current building code or flood standards. And I just want to be clear, I don't want to appear to manipulate any of the facts here. It is a freestanding residential structure. There are 4 lock-off units that the property appraiser has documented in their records, and we've used the lock-off units to demonstrate density, and we did that at the Row PD back in 2012. The property appraiser does call it out as a 2-unit duplex. We are looking to, so we do believe there's an argument that there are 4 units within the house via the lock-offs that the property appraiser has documented. We are not seeking to build back 4 units. We're kind of demonstrating that we're asking for less than we could possibly request based on that documented 4-unit within the structure, but we are only seeking 2 units, which is clearly documented on the duplex DOR code on the property appraiser. I believe in your packets you can see the 4 apartments that are listed. Some of them are very, very small in terms of square footage, but that just simply means they've been in the structure at a certain point in time and noted that there were lock-off units internal to the home. So we're looking to redevelop with a 2-unit structure. It would be one single building with 2 separate units in it for the owners to occupy. We're limiting the height to 25 feet, reducing the density by 2 units. We worked with staff. They wanted to see some enhancements as your code calls for when you do pre-disaster build back. So we increased our side yard setbacks to move the building further into the site. The build back will be to all of the current building code standards, flood standards, so it'll be a safer structure and improve the appearance of the property. Our master concept plan, because it is a small site, is very basic in nature. The dark gray represents the maximum building footprint. The lighter gray is the accessory structure area, and then the setbacks are shown meeting the full intent of your land development code, and we have the larger side yard setbacks shown on there as well. We are requesting 1 deviation as we're permitted to do through the PD process, and that is to allow for slightly larger square footage. The pre-disaster build back says you can build back to the same square footage. The units are very small, and it would really preclude the financial investment if we were only allowed to build a 652 square foot unit. So we are asking what we believe is still reasonable considering the neighborhood of 1,500 square foot per unit. That would allow the owner to make the financial investment to have a comfortable property, and we would respectfully submit that rebuilding to that very small square footage would if anything, downgrade the property by having such a small unit on site. So it would allow for 2 appropriately sized units, similar in size and quality. We're not seeking excessive square footage to build one of those kind of mega mansions you see throughout the beach area. And even with the larger square footage, we can still maintain all setbacks, including the more expansive side yard setbacks. Just to close up, we are in agreement with staff that this is fully meeting the intent and policies within your comprehensive plan, including the mixed residential category and your policies regarding mitigating hazards and allowing for pre-disaster build back for safer structures. Oh, I'm sorry.
Sorry. Take it. Okay. We still have 5. And this request, as staff has outlined very thoroughly in their staff report, does meet your criteria in 3485 for the Plan Development Zoning District. One area in the staff report was that they have to get a building permit. I believe it was stated within a year. We were working with staff, asking for a little bit more flexibility. They have not started designing. They understood this was a public hearing process, so they wanted to get past the zoning RPD stage before they engaged an architect to go through what is a costly process of designing the home. So we did request a 3-year time frame to get the building permit. We can agree to 2 was what staff had indicated would be their maximum comfort level with that, and that would give us sufficient time to really design the project appropriately, and we would respectfully request the 2 years
as part of your recommendation of approval, and I'm happy to answer any questions.
What's the total square footage right now on the roof?
It says 652 on the property appraiser site. The survey we submitted shows approximately 750 square feet.
Do I have to disclose that I may have sold this property years and years and years ago, or it might be the house next door because they were identical?
No. The issue about voting conflicts is whether or not voting on the matter somehow will give you
Yeah,
a
I don't
current
have it listed now.
be- benefit. So,
No, I don't.
Okay.
okay.
Okay, I just wanted to confirm that. Okay.
Tom, by right, they are allowed to have a single unit on that at this time? If they were to tear it down, a single unit up to side setbacks?
Yes, in the future land use mixed residential, they would be permitted to have 1 unit per 7,200 square feet, I believe. So the lot is smaller than they would be permitted to have 1 unit essentially. It is larger than the surrounding lots. Some re-subdivision may have occurred at some point, but it's not large enough to allow 2 dwelling units per the current density.
Anyone else have any questions? Dan?
No.
Jane?
Well, once again, I don't agree with the explanation of the pre-disaster build back as it was written back in the day, and my understanding of back in the day, but that was all thrown out the window with the pre-disaster build back that was at the north end of the island that gave them everything they wanted.
Not,
So I don't think there's any rules anymore with pre-disaster build back, so.
I do believe that even though town council voted differently, we still have a set in the code to still use at this time. No? We still have code.
What do you say, Sarah?
Well, I would say that based on the code, they can ask for a deviation from the code, and based on our reading of the section of the future land use map that has to do with pre-disaster build back, it does give the opportunity to request that. If it were in the low-density future land use district, that would not be an option, but because it is in the mixed residential future land use district, it appears that that is an option. So staff feels that it is a deviation that they can request.
Questions? It's public comment. Okay, I'm good. Okay, I'm going to open up for public comment. Step up to the mic and state your name.
My name is Donald Baker. I live at 275 Pearl, formerly 285 Delmar. I am a 1954 graduate of Fort Myers High School.
Congratulations.
Just to give you a little background, that this house was not built in 1946. This is one of the 2 homes that Lee County chose to move from Lanikai property to Pearl Street, which was zoned RS1, single-family homes. So this is an original zoning where it was deviated by Lee County to be a duplex. In 1986, I requested a home to be built. They rejected my variance of 4 foot in extra height. So I had to borrow a lot from my brother to build my home at 275 Pearl Street. Hurricane Charlie took care of my home. It was the fire on Fort Myers Beach. In this time, when we were allowed back on the island, my brother and I went to town and requested from Jerry Murphy to build a duplex. He said under the new zoning, it is not allowed, even if it was attached both ways, because it required 15,000 square foot of area, not the 5,000 that they are requesting. And he said to be able to get 2 lots, I could not build one house on the 1 lot and request another one later unless it was surveyed and 2 strap numbers were initiated. So it took me until 2007 in December to be able to move into my new structure. Okay, that gives you a little history about it. I have 3 items.
You have 1 minute left.
Pardon?
You have 1 minute left.
Oh, I did, earlier there was no time limits that
Yeah, there
was
was.
listed. Okay. The commercial zoning, this I understand to be a duplex, it has to be commercial, and zoning, no? Okay, but that's only extended 150 from Estero Boulevard. Third thing is that the RS1 zoning was before their 1984 survey, which was in their, the thing shows the house as it was moved there. The slide presentation does not show the house as it is now. We do not want a duplex there. This would mean that instead of having 8 people in the house total, which they say they could have now, we'll have 8 people in each one, which will make 8 or 10 cars available to that property and is much too dense for the area. Thank you.
Thank you. Anyone else?
Ralph Perry, I'm a resident of Pearl Street. I want to apologize, I don't have a fancy slide presentation. But I went through the staff report and I looked it over pretty closely. And throughout the report, the unit is referred to as a 4 unit, and on page 7 of the report, it's noted as 4 legally existing units. However, the Lee County tax site indicates it's 2 bedroom, 2 bath. And my belief that this unit is actually 1 upper, that whole upstairs is 1 unit, and there's a small unit downstairs. The survey that's supplied with the staff report dated 2/6 of 96 is also inaccurate, and the slide that was presented up here is also inaccurate. The stairs that are on the left-hand side or the east side of the house no longer exist, which only allows for 1 point of entry-exit for that entire upper unit. With that stairway removed, the only way to access 2 of the supposedly 4 apartments upstairs would to go through 2 of the apartments that are up there. There's no there's no slide up there that shows what it actually looks like on the tax assessor's site. They already covered it, but I believe the square footage is 652 listed in the report is inaccurate. It does not include what is referred to as an enclosed porch or the lower living unit of 292 square feet, which shows on the Lee County tax assessor's site. On page 10 of their report, they're saying that they're going to reduce the traffic by 50%, changing it from a 4 unit to a 2 unit. My contention is it's a 2 unit right now. The proposed site layout, they're talking about building a duplex there, and they have 1 driveway. And I don't believe 1 driveway for a duplex is going to cut it. It's going to be 25 foot long. I have a Mini Cooper that's 15 foot long. If you're going to have a duplex and you're going to have people living there, you're going to have to be moving cars back and forth. So I request that they put in another driveway, and at least on the drawing. If they put in a 10 by 25 driveway, that's going to increase the amount of, or decrease the amount of impervious area. and then it's going to go beyond the 60% that they've also recommended. The property right next door to it is a mirror image, 190 Pearl Street. And as Don said, they were moved there from down near Lonnie Kai somewhere in the 40s. And that unit right now on the property tax list is listed as a single-family resident. I can't believe that there's that much difference between the floor plan of that one and the one that we're talking about. And if you take a look at the Lee County Tax Site website and go into the floor plan, it'll show you the 4 small apartments that are like 8 by 10, you know, in that vicinity. They do not exist.
Please wrap it up.
The unit gets rented out on a regular basis, and there's a number of people in there, and I don't believe people would be renting it if there were 4 small apartments. And as a personal note, during 2017, there was an extensive amount of work that was done on that unit that I believe turned around and changed that entire floor plan on the upper structure.
Limit. Thank you. I appreciate your time.
Can I just ask a quick
You
question?
can ask a quick question.
Sir, what do you think the ultimate solution would be? Do you prefer just the status quo of the existing unit? Would you prefer that if it is changed, that it be a single-family unit? Is that, what's your ideal outcome given the challenges that you just presented?
I think that the unit needs to be looked at and reviewed, and I think it's not a 4-unit apartment. I believe it's a 2-unit, and it's 1 unit upstairs, and it's 1 unit to 292 square feet downstairs. I knew the people that lived downstairs, and they were there until Irma hit.
I mean, you see the...
I would prefer to have the unit stay as it is.
It's a 2-unit two-unit facility, and what it's being replaced with is a 2-unit facility. You're just concerned about the additional square footage of the 2 units?
It's the additional square footage, the height of it. We've recently had a home built on Pearl Street that went up 3 stories, and we've got 2 of them on the street, and they're too large for the street.
The petitioners reached out to you and tried to talk to you about your concerns?
No.
Okay. Thank you.
Anyone else for public comment? Come on up. The microphone.
Do you swear to tell the truth, whole truth, nothing but the truth?
Yes, I do.
The witness has been sworn.
I'm Sharon James, and I live at 275 Pearl Street. And I just wanted to say that I've been on that street since 2007.
Please talk into your microphone a little bit closer so we can get it on record.
I've been on that street
Thank
since 2007, and the owners have never lived in that property. It's been a rental property from the whole time. There has never been an owner living on that property. It's been a very bad property rental-wise for the street. They rent it to 15, 20 people. They rent for 2 and 3 nights, never for a week at a time. It's just become an eyesore. I think allowing 3,000 square feet, I can't imagine what they would put in there with 3,000 square feet. I wouldn't mind myself seeing a newer home there, but I do not think it should be a duplex. I think it should be a single-family home.
Thank you.
Thank you.
Any more comments, questions? Any more public comment? I have to close that first. All right.
None of these people own the house.
Looks like there's no more public comment. I'm going to close the public comment section and open discussion for us. Go
Know
ahead.
how long these people have owned this property?
No,
How long have the current owners owned this property? And what is...
Since 2005.
The other question I have is, what is truly legal on the tax rolls, legal rolls? Because it sounds like they say 4, tax roll says 2. What is technically legally there and allowed to be there and should be there, I guess?
I can tell you how staff looks at and has looked at the property appraiser site, and it's based on, if you look at the the building sub-areas on the descriptions. It lists 1, 2, 3, 4 apartments, and that's how staff has looked at this. Typically, there are a lot of houses that will say duplex or single family, and then they're divided up with additional apartments in them, especially if they're older ones. And I don't know how the property appraisers come up with that information, but that is how staff has viewed it.
May I make an observation?
Yes.
And I'm not trying to make any let's assume for the moment that it's 4, and the comment of the nearby residents is that it really should be 2. It's the application for you is whatever the number is to take it to a number 2, and that's it.
Yeah,
So,
I hear you.
Well, let me ask you though, but isn't that part of the argument for the deviation that, hey, we're doing a public good by reducing from 4 to 2 in return for growth and expansion of the, and that's the deviation? So it is material whether it's 4 or 2, right?
Well, yes, however, the building footprint is still the same whether it was 2 or 1. So that's where the struggle is, right, when we review these things is, if they built we get a lot of complaints about single-family homes too. The building footprint, the impervious surface, it's the same. So the number of units.
But you.
No, but my point is that the building size, the number of units, yes, is because they want to build more square footage. But if they didn't get this and they built 1 unit, it would still be the same size building.
I'm not taking issue with what staff's recommended, but my concern is that you always say this, Jason, hey, these folks have come with a special ask from us.
Right, and I'm agreeing with you that
Yeah.
is part of the request of
Yeah,
the
so,
reduction.
but in return for that ask, they're saying we're going to take it down from 4 to 2, but it sounds as if there's some dispute whether it's, all right, can I ask
Real.
Can I ask the petitioner, are there 4 different entities renting there right now?
Not know the answer to that.
Is the owner of the property here today?
They're not here today.
Thank you.
I would also submit that to justify the deviation, we expanded the side yard setbacks and also agreed to a lesser amount of impervious on site and then also the vegetation. So it was not just the unit count that was being used to justify that.
Owner been in contact with his or her neighbors about the proposal?
They indicated they had been, but we'll definitely chat afterwards and we'll move forward with communication. They couldn't be here today. They're
To Mr. Perry's point, the 1 driveway, was that part of the negotiation to remain under the impervious footage?
I believe we can still maintain the condition of the 60% impervious and expand that driveway. I don't think we're that close to tripping that threshold. So we wouldn't be precluded from expanding the driveway.
But I guess my question is why, if it's a duplex, is there only 1 driveway?
You can park under the structure.
30 feet. Yeah.
2 cars. Well, my issue with looking at these apartments, they're 108 square feet, 72 square feet, 80 square feet, and 100 square feet. I could have 10 of those in my house.
Those are bedrooms, or, I think in a 10 by 7 foot place, it would be hard to have a kitchen and a bed.
And a bathroom.
And a bathroom. So, and, I don't remember whether I sold the one next to it or this one, but
We have the pre-disaster build back, and the way that reads, I'm struggling with this.
the pre-disaster build back states that it should be the same square footprint.
Yes.
And so, but it could go higher, but that's also where we were to expand. that was to be able to keep the same number of units and go up in the same square footage. Well, these, I'm not sure you could call them units, and I'm not sure they were more than a duplex, because it does say it's a duplex elevated in a single-family residence model type. And it says 2 living units also on this document. So, if they say the effective year was 1980, so it was probably at the Lani Kai until they moved it in 1980 and built the Lani Kai. And at that time, they made it a piling house, which I believe they later filled in below because they wouldn't have had a ground level. These were probably a cottage on the ground.
I can see, some square footage, like we've had in discussions in the past of adding for ADA and bringing it a little bit more in compliance. I think this is a lot of ask when using this specific piece of code. We're going to expand the hallways, the bathrooms, we've talked about that in the past, that's been our...
accessible.
And making it more accessible. Yeah, we can see some expansion of square footage, but this is
We were even talking about.
2,400 square feet.
Yeah, we were even talking about just figuring out a factor to make everything wider.
But this is 2,400 square feet.
This is a big factor.
This is a little more than just a little increase in square footage.
And if there were 2 lots of record, that would also make a
Yes.
difference, but.
Any more questions of the town or of the applicant? I'd like to make a motion. Do I hear a motion? Or do we want to continue to discuss? Jane, do you have anything else?
Go to me last, I'm just looking at something.
Tim, do you have any questions? Scott?
No.
Dan?
I just really wish the property owner was here to ask a question about if they've actually ever lived in that property or if they've used it as a rental the entire time.
We have the option of, and for Dan to, if that's something you need, that we can push this and table this and have them come back.
For me, it's an intent. What is the intent of asking for this? Are they going to live in it or are they going to keep renting it? That seems to be the question that people are asking.
Have the answer to this?
I don't, and I would prefer to table it until they can be here rather than.
And I'm going to suggest we table this then.
Yeah.
And we get some clear idea of what's going on in this property.
I just, by way of information, I happen to be looking at something else right now, or for staff, regarding something you all have reviewed and approved a while ago. One of the conditions was, and for something similar to this, is no short-term rentals.
Oh, okay.
So, but, the point is that if they're agreeing to that.
I think that why we are sitting here staring at each other is that, one, I think there is some question as to what's the legal units on this, because there's multiple ideas there. If we can get that cleared up and get a better idea of that, I think that it would be nice to know the intent of this, that would help make a decision here. So, and as the applicant is asked to have it tabled, I make a motion to table it till next meeting. Can I do a date certain on this?
If you
Or
know
do
that
you
you'll
wanna-
have the answers before.
Well, I could add something to this. When it was purchased in 2005,
She's actually asked for it to be tabled now, so we can
okay.
get that answer from the
Okay.
owners at this point.
With respect to the chair's motion, if I might suggest as well to the petitioner that if we do table it, that particularly since folks have taken some time out of their day to be here, that you have the owner meet with them and try to address some of their concerns before you come back again. That certainly would help me be more comfortable with things, assuming you can address some of those concerns.
I apologize for everyone having to wait all day through this, but I think that we've got a lot of questions and concerns about this, and I think it is best that we table this.
To that issue, certainly they're entitled to come back, but their testimony is already in the record, so if they elect not to, that's their option, but their comments are obviously part of the record and before you all and can be considered by you today and moving forward.
Are we okay with November? Okay, so I'm going to make a motion to table this to a date certain to be seen on November's meeting.
I'll second it.
What?
Which is November 12th.
November 12th. Dan, you still second?
Yes.
All in favor?
Aye.
Aye. Anybody opposed? All right, so it's been tabled till next month.
November 12th at 9 o'clock, just for their information, yep.
For now.
All right, so now.
It changes every month, so.
Okay, moving right along. Where'd that agenda go again? All right, we will now be opening up the public hearing, or the first reading and public hearing of ordinance 19-15, amending the short-term rentals qualifying condos.
It's styled as first readings is when it goes to the town council, but for you, it's
It's just a
consideration.
it's just a-
Yeah, it's a public hearing.
Public hearing for. All right, so let's open it up. Town? You got nothing? It's,
Yeah. The town staff directed, or town council directed staff to work on an ordinance that would provide for short-term rental uses to be allowed with minimum restrictions in properties and locations that existing condominiums that can demonstrate that that type of activity is authorized and allowed by their existing homeowner regulations, condo association regulations. And so that's what we've done. I think the discussion that the town council would like some input from the LPA is there a date? There was discussion at the town council level when this came to them as a discussion item that the date for establishment of the short-term rental would be the date of the actual adoption of the short-term rental regulation. So whoever wants to take advantage of this exception would have to be able to demonstrate that short-term rentals were allowed and were taking place at the location in question as of the effective date of the original short-term rental regulations, which I believe were adopted in.
yeah.
I think 2014 is a month in 20. We can obviously confirm that, but that's is that the only criteria that you all would like to see in the regulation?
Well, there are a couple other, so wait a minute. I just want to understand, so what you're saying here is condominiums don't have to opt in or opt out, they just have to register?
Yeah, that's correct. They have to
And
register and
they can-
provide evidence that they.
Based on their condominium documents, rules, and regulations, if they can prove that they rented 3 days, they can rent 3 days. If they rented 7 days, they can rent 7 days, whatever and they were basically self-govern.
Correct, of course, except for the registration requirements.
Can I ask why, other than fundraising, are they being required to register?
Not fund, I'm sorry.
I think it's fundraising. If we're not
It's a way-
governing, how are, what
So
what
we
is the
know where they
purpose?
are in case there are noise complaints or other types of complaints that are not related to the use itself. The only way we would know that they're there is if they've been registered.
But they don't have to be, if they're in a condominium and they rent today, or they don't rent today, but choose to rent tomorrow, they could, by registering, rent, correct?
Correct.
Why are they
You're-
exempt
I
from
think-
our short-term rental?
Can I-
Because it was only single-family.
We're mixing two different issues. You're mixing registration requirements
Mm-hmm.
versus length.
The ability to do it.
Mhm.
So what this ordinance does is it codifies and recognize those prior uses as long as they can provide, again, the threshold evidence that they're allowed and that they were taking place on whatever date you all recommend.
So this is going to, hang on one, so this is going to stop if, so let's say this Pearl Street, by example, decided to go condominiums. They couldn't then all of a sudden say in their condo docs, there's 7 days, and now all of a sudden we got a 7-day rental halfway down in a monthly zone. This is just stating that
That
if,
street is
if
weekly,
they
so-
rented for 7 days before X date, they could still rent 7 days. If they rented 30 days, they could still rent 30 days, is in this.
That is, that's the,
Essentially what-
that's the
okay.
intent,
That's a
yes.
bad example, because Pearl is a weekly
Well,
rental.
but
So, I mean, if it was in Laguna Shores.
it could be my street, it could be Hibiscus, if somebody
We're
put a
we're
duplex
talking,
and
we're,
condoed
we're,
it.
we're talking about condominiums.
We're just, exactly, but we've allowed for some of these duplexes to condominialize, and I just want to make sure that we're stopping, that's pretty much essentially what we're saying here.
Yeah, and I think that there's a minimum number of units.
6, yeah.
Well,
So
I
that
have
would-
to say that, I sold a hotel on this beach that I owned, and they were all one parcel, well, no, they weren't. They were, yeah, I think they were, but we subdivided them into lots and condominiumized it when it was sold, and they rent as a hotel, and they are considered a hotel. So,
But the
But
zoning
they're-
drives
So
that.
this doesn't really apply to that. Okay, let me be sure everyone understands what the issue is at hand. The issue at hand is that we had certain condominiums that pre-existed our short-term rental regulations. They, when the town was allowing people to apply for shorter durations, they didn't apply because they felt that since their condominium rules allowed a shorter duration, they were covered. So what we're trying to accommodate is that if prior to the short-term rental registrations that the town put in place, if they had a shorter duration allowed in their condominium documents, we would respect that shorter duration. That doesn't mean that a new condominium that came after our short-term rental regulations can do this. One that's created today or next week can't do this. This is exclusively for the folks who had within their condominium rules, so when people bought those properties, an understanding that they could rent for a shorter duration.
so you're saying that the pink shell condominiums that were built after our short-term rental thing cannot rent on a...
If they have a problem, if they have an issue, they are not the ones who came to us with the problem. The people who came to us with a problem that we're trying to cure is a small group of condominiums that specifically said that, hey, we, in our condominium rules, and our condominium was pre-existing, your short-term rental regulations say that we can rent for 3-day minimum. Your rules don't allow us to do that. We would like to be able to do that because people bought and sold property under the premonition that we could do that. And we said that if you, in fact, predated our regulations, and that was your condominium rules, if you give us notice within a certain deadline, at this point it might be the first of the year, we will respect that. And that's what this amendment accomplishes. It's not trying to cure any other issue.
So does the whole condo have to, can a condo apply for everyone?
How they register
Or
is
is it-
not
or
discussed
is it
here.
each-
It's just duration. We're only talking about duration. We're not talking about any other aspect of the registration. We're just saying that right now, under our current regulations, they're written, if they're in a 7-day zone minimum, they have to rent for 7 days, and if they're in 30-day zone minimum, they have to rent for 30 days.
Well, I think it's important to say, if this condominium could rent for 30 days, it's not these 3 individual units that rent 3 days, it's the condominium.
It's a condominium, it's the condominium declaration. It's not
There are
the,
rules and
it's not the,
regulations
it's
as
not
to
the
when they
unit,
can-
it's
yes.
not the unit.
Okay,
It's not
that's what
like
I'm
Joe
asking.
wants to and Mary doesn't. It's
Yeah.
it's either was in their declaration of condominium prior to the code, and they would have to give us evidence of that,
Okay,
or it wasn't.
okay.
So we're just trying to make sure they weren't inadvertently harmed by our ordinance.
So basically, I did type up, or I did bring in a copy of what Jessie stated at the town council meeting, and she indicated that you were in agreement with what she stated. Are you,
Well, I believe this cures the relief she was asking for.
Okay.
And obviously, it's part of the public record as it was on the town council agenda, and now it was on your agenda. So clearly, if it didn't, well, I'm sure we would have heard from her.
Well, and the intent of the short-term rentals was to stop the intrusion of commercial into single-family residence. And that's what it was all about, was the areas that they wanted to make quiet areas because they wanted to not have the weekly intrusion of commercial, is what they were calling it. But that's why condominiums were not even discussed, because they are a commercial entity and not a single family. So that's why it wasn't ever discussed. That's why I really don't understand why they're.
Commercial entity, condos individually
Well,
owned homes.
because it is a mass, it couldn't be said that you wanted to keep intrusion of other, being intruded on by the other units in the building. It was single-family houses what brought short-term rentals to light.
So just to be clear, this doesn't change anything else in the ordinance other than if a older condominium, prior to the town's regulations, had within its declaration of a condominium that when you bought that property and you signed the receipt of those documents, that you could rent for a 3-day minimum, that our ordinance does not exempt or prevent them from doing that. It's that simple. It doesn't deal with any other issue whether that you like or dislike about the short-term rental. It's a very narrow approach to deal with a very specific problem.
Are you putting a date on this now, or?
Well, the date, we're assuming that the council approves this, we would give folks a fixed period of time to present their evidence that they qualify under this ordinance. Would probably be, I don't know, January 31st at this point, based on how I see the schedule playing out. As to when they had to have this in place, it would be before the town's short-term rental ordinance went into place.
Which again, I believe is in
So,
2014.
I still ask the question, other than the benefit of having the knowledge of, the condominiums they have to apply and do all that kind of registration at their condominium. So by having them double register with the town, are you governing them, or?
No, we're not asking them to double register. We're asking them to come in and show that they had a less than 7-day.
So they don't have to, the people who rent in a condominium don't have to register on the town's
They
list?
do, per the ordinance, irrespective of the duration, okay? That's required today. What this does is say that right now, the least period of time they could rent for is 7 days. This would allow them to go to 3 days because that pre-existed in their documents. It doesn't change anything else.
It's basically a grandfathering provision, is that fair?
In essence, that's what it is.
But if that particular condo association decided to go from 3 to 7, they'd have the right to do that, correct?
Well, they would have to modify their condominium documents through the formal process required by the state to do that.
Okay, thank you.
Any other questions? All right, I'm going to open it up for public comment. Anyone here to comment? All right, I'm closing public comment. Any other discussion of?
It says in here that to notify by November 30th, 2019. Is that the date that you're talking about, that it fluctuates?
That'll probably be by January 31st,
Okay.
2020, because of the timeframe of getting it through LPA and council.
I'll make a motion to approve the ordinance 1915, the Town of Fort Myers Beach, section 2391 of the Development Code, excluding condominiums from the restriction of weekly rental in certain zoning restrictions, providing the severability of codification, what is this? Errors and conflicts of the laws, to provide, basically to provide less than 7-day rentals, provided they show documentation that they were in line at the same time as the
Prior to.
prior to, the short-term rental um, being brought in.
Okay, and do you all have a recommendation as to when they have to come in and provide that information to us? Obviously, the November 30th date is, I'm sorry, obviously, the November 30th date is outdated because.
30 days from approval by town council.
I think that's too quick for,
quick.
if they
That's
have to
too
have a
quick.
meeting, if they have to do anything, I would give them 60 to 90 days
Well,
from
don't
the
they just have
hearing.
to come in with their condo docs and prove it?
Yeah, but.
But they'd be here.
But they can't do it until they know
Their
if they should
presidents
do
or
it.
whatever has to be here. I would say 60 to 90 days from council
How about we
approval.
just, we
By
put
January
in,
31st?
60 days from the effective date of this ordinance?
That's fine.
Fair.
That's my motion. Anybody second?
I'll second it. All in favor, say aye.
Aye.
Aye. Motion passes 6-0. Moving along. Okay, we're cranking now. All right.
About to slow down.
Oh,
Yeah, and I've got to leave at
oh,
3:30
Yeah. 3:30?
at the max.
Okay. I'm going to open the hearing for variance 20190058, the Tiki Hut setback.
Good afternoon, Kalyani Butara, Community Development. And a case number VAR 2019-0058. An applicant who's the owner of 3597 Shellmount Boulevard is seeking variance from Town's Land Development Code Section 341174 and Section 34638, which contains requirement of minimum setback for the residential accessory structure. This variance will allow a tiki hut on the waterfront lot to encroach 4.4 feet into the 10 feet accessory rear setback and 3 feet into 7.5 side setback. An applicant and agent is attendee if you have any question.
The applicant and representative, like this. You can go over there if you want.
Sorry, I also hand out the new conditions of approval in the morning.
Yeah, these are the ones she handed us this morning.
Oh, yeah.
Oh, I didn't.
Page 158, she replaced out,
There's-
158 of our packet.
Yeah, there's some revisions per some other staff input recommendations.
So they changes the conditions of approval. Condition 1, the tiki hut may not be modified, repaired, or rebuilt, or the hut will be brought in compliance to meet the setbacks within 5 years of the effective date of this approved variance. Number 1 was changed.
Good afternoon. My name is Ryan Murphy. I'm from the Law Office of Kevin F. Trzynski. I represent the homeowners, the current homeowners, Lori Carroll and Mrs. Steele, Kimberly Steele. It's just by way of backstory. This is kind of an unfortunate incident. I've never heard of it happen as for real
Couldn't be
estate
down here.
happening. Okay, so I'm sure. Yeah, if walls could talk, I guess.
Not the first rodeo.
But, so anyway, what happened here was we had a seller, a previous owner of the property, it was a mother and daughter, Scalzadona. What happened was, they had, it began with a dispute with the neighbor. The neighbor's Robin Driscoll. And I guess I've come to find out, this is before he purchased the property, during the weekend, the homeowners then decided to build two rather large tiki huts on the property without getting any governmental approval, so no permits were pulled whatsoever. Upon Robin Driscoll's return, again, she's the neighbor, then that's when this whole issue arose. So what happened was code enforcement notified the homeowners that there was a code violation. You built two structures without a permit. They were notified, the sellers, and they actually attended before a magistrate. So an order was actually entered requiring them to come into compliance. Now, instead of coming into compliance and getting a permit for the two structures, they decided to sell the property to my client. So they've, in effect, inherited this mess, which has led to my involvement and substantial financial burden on the homeowners, on my clients. So when they came into my office, essentially the course we took was I said, well, first of all, knowing that this body is going to have to understand the effect of the neighboring properties, we notified all the neighboring property owners. I think it's important for purposes of this that that we do get their consent, or at least get their notification. In the letter that I provided, it's in the packet, I will point to what I think is really relevant here, though. In the letter, I gave all the neighboring property owners an opportunity to look at the structures, voice any objections they have. We were willing to work with them if they had any issues. What my clients did do was, the larger of the two tiki huts, they decided that given how evasive it was, I guess, on the neighboring property, that they did take it down. So they purchased a demolition permit, hired a contractor, and removed the larger tiki hut. So the small tiki hut is all that currently remains on the property, and that's down to the water body. So that's the only one that's really at issue here. It's important to know that when they purchase this property, these tiki hut structures certainly materially affect the value of the property. Because we had to remove one, we've been hurt by that, including the cost of taking that down. It was certainly a material reason why, and Lori is here if you have any questions for her, it's certainly a reason why Lori purchased the property, and it weighed into that decision. As the LPA may be aware, there is an affirmative duty now when you sell real property to disclose any material defect. The fact that these sellers sold a property knowing of noncompliance with code enforcement would be the non-disclosure of a material defect. It is, in fact, a fraud on the civil side of things. So we think this is an exceptional circumstance that does give rise to the variance. I won't go through in detail what the town has recommended. Everything I've said here is pretty consistent with their findings, and we are totally in agreement with that. Now, the issue that's kind of come to light today actually, you've referenced the change in the conditions of approval. As of yesterday, the conditions of approval recommended by the town was that the tiki hut may not be rebuilt. We totally agree that that would be the case. In fact, the town's code of ordinances does state that when a structure that's non-conforming no longer exists, it cannot be rebuilt. The variance by operation of law vanishes. So we agree with that. The only issue now is that we've changed today. The state's sorry, not the state. The town has changed, and they're now recommending that the structure cannot be modified, repaired, or rebuilt. Again, we're okay with rebuilt. I think it is unreasonable to require somebody who has a structure on their property to not be able to maintain that structure. So I'm not understanding how we would have basically, by their recommendations, we cannot fix or repair the structure at all. So by way of example, if the thatching was removed and it started leaking, we would like to have a way in which to fix that. We're not talking about rebuilding it. That is, we agree that we cannot rebuild it. So, and then my client thinks is a bit of an unreasonable restriction is the 5, and again, I'm not really understanding the wording, but the wording here is that, or the hut will be brought into compliance to meet the setback requirements with 5 years of the effective date of this approved variance. The issue there is that this cannot, the structure cannot come into compliance. It is 4.4 feet over the back setback on the water line, 3 feet on the side setback. So we really can't bring it into conformance. Essentially what this would do is limit the variance to only 5 years. We would then, 4.5 years from now, be stuck in the same position, having to tear down the current tiki hut, losing further fair market value to the property. The town has identified that the property value has decreased because of this. So again, we think this is an exceptional circumstance. It's an unfortunate incident. I can tell you that my clients have paid far more to my firm and the application process than it would be to tear down this tiki hut. It's a minimal impact on the neighboring property owners, and within the package, and again, if you want to get specific references, I can give those. Within the packet, Robin Driscoll has consented. That's the neighboring property. She understands the large tiki hut has taken down. She has no objection whatsoever to the current location of the small tiki hut. And also, in the letter, we notified the property across the canal They've also, within your packet, they've come back and affirmed that they have no objection whatsoever to the variance. So there is no impact or objection from any of the neighboring property owners. My clients have been great to communicate with them and give them any opportunities to voice their concerns. So with that, we'd respectfully request that you grant the variance as requested.
Why the change?
I guess further consideration, it's, I guess the only way to describe it is it's like a sunset, essentially. You got a property owner that's inherited a problem, as was stated, and so it's not a true hardship. However, it gives them a time frame to utilize it until they have to come into conformance.
Would the town be fine with taking the repair piece out and doing the modified or rebuilt piece? I understand what he's saying, is that if the roof starts leaking, you kind of...
The problem, yeah, it's a catch-22, because you can repair and repair and repair, and you can individually repair a structure, in this case a tiki hut, and over the course of 5 or 6 repairs, now have essentially a new tiki hut.
Well, can we call it maintain or whatever? Because there is a difference between maintaining and repairing something that is structural. It's the difference between replacing the top piece of wood on a step versus replacing the stringers. I mean, can we do something along those lines so that they at least can maintain it, but not? Can we draw a line there? I get what they're saying.
Sure.
Yeah, the town's the reason why the town is suggesting this is that it does provide for essentially what lawyers call the amortization, the phase out through natural obsolescence of the structure, and ultimately compliance, which is what but for someone doing having built these without a permit, which would have caught the issue, we wouldn't. And so it allows them the benefit of the tiki hut for a period of time until it just starts,
Well, and I get it, and that's what I'm saying.
So
At some point in time, this thing is wood. It's going to go. It's the beach. It's rotting. It's going to go. And then at that point in time, all bets are off. It needs to come out. But my question, though, is that like simply a roof leak, at this point, is the town going to come after them if they decide to fix the roof and a leak on it? Because we have something as vague as repaired in here.
It's certainly up to you all to recommend to the town council what you think is within the code is if you repair of any structural element, and maybe that's the way to. Well, they can, in my view, based upon what I know about tikis and this one in particular, having reviewed the photographs, then that would allow them to repair a leak. But if the stringers or the structural components started to fail, then it would have to be removed and couldn't be repaired, because that's not necessarily maintenance.
I'm thinking more along the lines of maybe taking, and I don't know if my fellow members are in agreement, taking the repaired out, allowing to maintain them, but once it gets beyond a simple fix, then it needs to.
I agree with, repair to maintain can be construed as a few different things, in my opinion, but correct me if I'm wrong, if they do any repairs to it, would they not have to come through and get a permit to do some repairs, and then it would be, what could happen under that repair would be already told to them by what they applied for on a permit?
No, I think, hi, everybody, again. So I think what we're trying to do is, we understand a little bit that these people sort of got dealt a bad hand, okay? But we also are trying to also recognize we have a community here, and we don't want to send a message out that people can do stuff, and people can come here and and we can magically wave a wand and fix everything. So, in our opinion, this tiki hut was built without permits. We don't even know anything about it, but fine. And a couple of neighbors don't object. That's great. And so we're saying that rather than coming here and ask you to order them to tear it down today, which we would typically do, we said, we understand their circumstance. Have it, whatever its useful life is, and then if you want to come back and make a request to repair it, replace it, whatever, that goes through a whole new proper cycle for that question. So we're saying that have it, use it for its current service life, and then if you want to put it back in the same place, put it in a different place, get a bigger one, smaller one, whatever you want to do, come back through our normal process. We'll be glad to review it, consider it, and deal with it.
And I agree.
But we're just trying to bring this
Yeah.
specific situation to finite closure.
And I agree. The question really came up is what's the useful, a simple leak if somebody went up there and fixed a simple leak, is code enforcement going to show up? But yes, I agree. Once the useful life is done, it comes out.
If
How do
it
we
would help,
maintain-
if you want to say that we will allow, one rethatching of the tiki, that's fine. Again, I think Mr. Herron was saying that we have a lot of scope creep with things, but if you want to say, okay, we'll allow them to rethatch it one time, fine, let's just make sure we have a closed loop when we're done with this. Because we just don't want to be that, well, we're fixing this, we're fixing that, and 25 years later, it's still there.
Question. It was the first notice of violation July 12th, 2017, and they purchased the property July 9th, 2018. And there was no disclosure given by the seller that there was an illegal or non-permitted use?
Yeah.
And nothing showed up of open permits or anything because there wasn't a permit?
Yeah, so this is totally a latent issue, so there was
Did
no.
they give you a seller's disclosure?
Yes, and it's silent as to the code violation.
Okay, I've been looking for it.
It's in there and they did not disclose it.
So if they built this in 2017, I would think 10-year life on a tiki? So maybe extend this 5 years to 7 years?
Contract.
'Cause like he said, they're gonna have to be right back here in 4.5 years.
Yeah, so I think there's kind of two issues here. One is, what is the maintenance? I can assure my clients, they're not going to go over and above, but again, I'm sure people have come before you with a lot of promises that have went awry. But so that becomes to the other question is, we talked about the service life and the useful life. My position is that 5 years is a rather short window for a brand-new tiki hut's service life. I think that limits my client's use of the property and the enjoyment of a material reason why they purchased it. I think due consideration has to be given to the effect of the surrounding properties, what my client has done in order to facilitate a resolution here in meeting with all these people. I mean, these are exceptional people that have really gone out of their way to try and make this, to get this rectified. And I think that this is not a little ask, or this is not a large ask to simply ask that the small tiki hut, the large structure has been removed at cost to us, and this is a very small tiki hut. I don't think there's pictures in the agenda. It's certainly not an eyesore, if you will. It's surrounded by foliage on one side almost completely, so it's not a very visible structure. It's limited visibility from the road, and you can see its location. It's rather hidden from the public, so I think there's consideration there. But my opinion is everything was great this morning, and then we kind of got blindsided with the report, the recommendation from the staff today. 5 years, I think, is a little unreasonable, just given the exceptional circumstances and my client's conduct in this matter. So just to answer your question, Jane, the notice of violation was initially on July 18, 2017. The code enforcement hearing looks like it was on November 29, 2017. The sellers were actually present at that hearing, so they certainly had knowledge of it.
I'm curious why there isn't $1 million fine on this building, because it's $500 a day after a certain period of time, right? That's in here.
No. Oh, you mean in the magistrate's order?
Yeah.
I don't know what the magistrate's order, was it $500 a day?
Yeah.
We can,
It's accruing.
And so there's a lien on this
So
property
who
too.
gets to pay for this?
I can speak to that. So we came with the staff, we had an abatement agreement of the code enforcement violations. So there is no fine, there is no lien on the property. That's part of your packet. We've extended that out. I think it expires, I think it expired at the end of last month, and the staff has said, well, we won't take action until, because we've been going through the variance process, the staff won't take action. So I think obviously, if it's denied, that would certainly start the fines. But the fine imposition by the staff, and again, the staff can speak to this, it has been abated pending this review.
The original lien, original fines have been abated from the previous owner.
I don't know the answer to that.
But yes, it sounds like we're working with them.
Yeah, so. Let me put it, I've not been contacted by staff on this issue. The first I'm aware of this particular code issue is here today, or not here today, but in the process of reviewing the agenda and you know, because I'm required, I'm tasked with reviewing the staff reports, and so that's when I became aware of it. The code violation and the code hearings predate my tenure as the town attorney. So I cannot necessarily at this point in time tell you all from a legal standpoint where things stand. We can certainly find out and provide that information to certainly the town council if that's.
Yeah, it's just for the record, it's in your packet, it's 266 is the compliance agreement.
If 5 years is unreasonable what is reasonable to you?
Well, our position is going to be that we would let the land development code come into effect, meaning that at a time when the structure fails completely or a hurricane knocks it over, then by operation of law, the variance is gone. This is not a variance that is going to last forever, certainly because the code just doesn't allow for it. So once it's down, we will have an inability to pull a new permit because the variance is then gone.
Yeah, the town is asking for some sort of sunset, which is what put this in here, so.
Well, again, our sunset position, 5 years is what the town's asking, but
but the town is also saying you could keep repairing this if we make some of these modifications, and it won't have a sunset. That's where
And I understand that completely, and I agree that, I mean, I don't know what the useful life of a tiki hut is. I think 15 would be at the upper end of it. So I guess if we could put somewhere in there that 15 years would be fine. The issue here is my clients they didn't get the benefit of their bargain by purchasing this property.
Sorry. So a couple of questions. I heard some follow-up questions. I want to see if I can come in here and clarify them for you. So we're here, we're basically talking about the zoning element of this to try to see if we can find reasonable ground to recognize the fact that perhaps, as I said earlier, that the recent purchaser got a bad deal. Now, you know, in terms of code enforcement, we still have a building without a permit that still needs to be resolved and all that. Now, but if you were to say that they can't have the structure today, that would obviously solve that problem. So we're going to see what happens today and with town council with this element, and that will give us guidance in how we deal with those other elements. So the real question becomes is that, you know, you start extending, I don't know if she's going to go around and sell it, and now, well, now it's a legal structure because you guys now gave it 10 years, and then the next person doesn't know that, well, they only have X number of years on this thing. You know, if they say 5 is too short, fine, let's go 7. But, and if they say they want to be able to do some maintenance, let's say fine, you could rethatch it once. And then after that, you're back at square one, you go through the process and rebuild the thing correctly the way it was supposed to be done on day one. And if this board, whoever's sitting here at that time, and town council agrees, they could have their tiki hut in perpetuity at that point.
Can I ask while you're up here?
Sure.
On this compliance agreement, it says that a fine of $250 a day beginning on September 20th, 2019, and continuing every day, every calendar day. So is that happening right now?
No, as I said, I mean,
By signing this
I'm here today because I think there is a middle ground to help these folks out. I don't know if it's as big an island as they would like it to be, but I think there is a middle ground to help these folks out. Whether they have recourse with the person who's holding the property about non-disclosure, I don't know about that. I'm not an attorney.
I just want to clarify so that she knows when she leaves here that there's a $200 fine or not, because it says if it is not completed by this date and time.
Right, so
The
there's
fine
two
starts.
elements to that. One is that they have to get zoning approval, which is why they're here. And then the second thing is, I'm sure that we're going to require some evidence that the thing meets minimal building standards. And I'm sure that we'll work that out if they survive this process.
Isn't there different codes for these Indian?
The only code difference is that if you're a Native American builder, okay, you don't have to be a certified contractor. But you still have to get permits. Everything else is the same. The only difference is you don't have to go through the state process to get a state construction type license.
Oh, that's a big misconception on the island.
I bet there is.
Oh, that one's.
I bet there is.
And that's probably why they got to where they are today, is that the conception is that if it's a Native American builder, he doesn't have to get a permit.
That exemption only applies to licensing. I think Mr. Herron and perhaps this gentleman
Yeah,
can
I
speak
mean,
to that, but-
and that may be a misconception, misunderstanding, but you still have to meet zoning. That's why there's not a blanket exemption. It's not in, at least my understanding, it's not interpreted and applied that way across the state, but a lot of misinformation out there, unfortunately.
Yeah, I think they're exempt from the licensing requirements, but they're not exempt from the permitting requirements. So just by way of history here, the magistrate determined that the violation was because we didn't seek permits for the structures. So what I had to do was apply for a permit and get a formal denial, and that denial was because it violated the setback requirements. So when we become compliant, or the variance is granted, if it is granted today, we do understand that we still have the necessity to pull a permit and get the permits, get the last structure permitted after the fact. So we do know that's coming. We just want to be able to have the permit violate, or the variance over the setbacks requirements, because that alone is the only way that we could even seek a permit and get an inspection. So we do understand that.
I find it hard to believe that the owners and their attorneys and their realtors had no idea that there was a lien on this property and a violation, and didn't disclose anything like that.
It's stated in here that the town did not file the lien on the
Yeah,
property.
just for the record, there was never a lien. If there was a lien, that would have given us notice, and we couldn't be here today. So there was never a lien
during
filed.
this process.
And under the process, the lien only gets filed after 3 months of noncompliance. That's what the state statute in our code says. So the next step would arguably, I would say.
This was in 2017, so I'd say we've missed the 3-month period, but.
No, the date for compliance.
Dan, do you have any questions? Dan?
Yeah, I got it. When does the town generate the letters that go out? Does the town get alerted that there's a new homeowner? Because I noticed that their letter went out after the purchase. Or is there just every couple months you send them that there's a violation of the code? Because I know that the previous owners were notified of it, and then they chose not to do anything after the magistrate hearing, and then decided to sell it and not inform the new owners of it. And then shortly thereafter, they received a letter.
Yeah,
saying
staff, code enforcement staff does, there's the next step would be to issue a notice of violation, which is what happened, and that's when the current property owners came in and entered into the compliance agreement. So there is a progression in the process. And to some degree, how soon or how long that sometimes takes to go to the next step is dependent upon the nature of the violation and how active the property owner is, and working with staff to resolve the violation before it gets to the hearing stage.
I'm in agreement with the council about being something dropped on your desk the day of or the day before. You're supposed to make an argument on something. It's difficult and it's hard to do business that way. I agree with the one-time thatching of it. That could be covered as the repair. The 5-year thing, to me, putting a shelf life on something, we've all kind of said is going to be the 15 years. And now we're saying maybe go to 7, and it's already been there for 3. What's the point of putting
Original
any?
was 5 years.
Huh?
Oh, she was asking me a question, sir.
Well, that's what's in here, is essentially we're telling them they can use it for 5 years. And then they either have to bring it into compliance or tear it down.
Well, no, the way it reads to me is that as long as it doesn't have any major issues, they can use it. Once they need some major modification or major repair to it, it then has to come in.
Maybe
Or
I
rebuilt.
misunderstood.
No,
I thought,
They sunsetted and removed it.
The amendment,
You don't have the new one.
today's
my
amendment-
understanding was that after 5 years, they have to either bring it into compliance or remove it.
Setback, yeah. They have to either tear it down or bring it into compliance within 5 years of effective date. They have to move it back, which they can't meet that requirements. which
Essentially,
means they
we're
have to
telling
take it
them in 5
down.
years, they have to take it down.
Yeah, if I think the way that I'm reading it, it's against my position, but I think it's in effect a 5-year variance. I think
That's the way I'm reading it.
And again, our position is that is a rather short lifetime.
Well, the town has now offered 7.
Okay.
But again, I have a problem with if we're at 5 and we're willing to go to 7 and we're saying it's a 10-year shelf life on it anyway, what is the point of putting a 5-year term on it?
Well, the other option is we 86 it and say they can't have it at all because it is technically unpermitted structure and it's not supposed to be there at all. That's the other option. I mean, we're trying to come to some middle ground here on all of this, and I kind of see both sides of it. But it is an unpermitted structure. Unfortunately, they got the shaft on this, but, so I mean, what is the middle ground?
Well, I mean,
They removed the
up until a day ago, number one was it was okay to not be rebuilt. So, I mean, I see his point, as I mentioned earlier,
That's the
that,
question I'm asking.
that,
Where
you know.
where did it come from?
Well, I think they've explained to us where it comes from, but I just don't necessarily have to agree with where it came from. So, and that's the point I'm making, is the way it was worded originally, I thought was sufficient enough. Now that they're putting a 5-year limit on it, that they can use it, and then they have to essentially tear it down because they can't rebuild it. To me, I don't know if that's necessarily fair.
How about middle ground being, it's sufficient useful life and be done? I mean, I don't.
I mean, if in my opinion, if we're set on putting a time frame on it and we're using the rethatching at one time in its year, if we're going to go to 7, why not go to 10 then?
Okay, let's go to 10.
Make the motion.
Make the motion.
I guess that would be my question.
You can make it 10 if you'd like. I mean, go ahead.
Well, yeah.
Oh.
You're away
sorry.
from the mic.
Two things. I'm sorry, well, actually, one thing is we do need to open a public hearing before you have
Motion,
a
yes.
motion and start discussing the motion, which I think you're
Okay.
pretty close to inviting such a motion to your peers on the board. So.
Have any questions down there?
Thank you.
Okay, so any other questions of the applicant? Tim?
Just a couple. When I look at a tiki hut like this, I look at a main structure, which is the heavy poles. Then I look at a substructure, which is the stringers running along the roof. Then I look at the thatching. So you've got 3 main components to building a tiki hut. I think when we look at this, and chances are, and I agree with Dan, that the main poles are probably put in there, and they're designed for a shelf life of about 10 years. I don't think that the stringers or the thatching is designed to be there for 10 years. But I agree with going with one rethatching. But I also have to look at it from the standpoint of, yes, the town wants closure to all of this. So I would look at the idea that if any repairs to the main structure and identify what the main structure is, say, okay, that's a no-go item. Any repairs costing more than a certain percentage of what the value of this thing is a no-go item. Set a percentage. But give them one thatching. But give them the ability to repair certain things as far as if you do have a leak, it can be repaired. It just can't go over a certain amount. But, if nothing happens in it and you live the shelf life of 5.5 years and now I develop a leak and I want to change the thatching on it, I have that ability of putting one thatching roof on it and allowing it to go for 10 years and then I call it quits. But I have to look at each component separately. Because you can't just say, well, hey, this thing is designed, and I've seen thatchings in other parts of the world that have lasted longer than we have been alive. So I have to look at some of this stuff and say, how this is constructively built.
If I may, is it possible that we could limit it to any repairs requiring a permit, which is that when it comes into the structural integrity of the structure, any repairs requiring a permit are not allowed?
Well, the re-thatching would require a permit, so,
With the carve-out of the thatching, yes.
in my opinion, I don't think it's right to have this be brought in because it wasn't brought up by us. This was what was advertised, and this was what was, public.
Original condition?
Yeah. To change this and have him on this last moment have to fight to do anything, I think that the tiki must not be rebuilt, okay? And,
But if it's continued to be maintained and it could be there forever.
well, they're excusing her for purchasing it without knowledge that it was not done with permits or legally done, then I think she's already done one taking of, she already took out one whole thing that was the bigger one. I think she's shown good neighbor kind of things, and her neighbors all signed off saying that, they've read it and they didn't have a problem, and you don't see anybody here, or have we?
Don't know yet.
We have somebody over there. So I'm open to public opinion first.
Any other questions of the applicant or town? Okay, then we'll open up public comment. Anyone here to speak? Either way. All right, I'll close public comment.
There's nobody here to fight it. To me, they were all advertised, they all got the letter that the conditions of approval were out there for them to review. If they had a problem with it, they could bring it forward. The town presented this as a acceptable approval with conditions.
Let's kind of go back to variance 101. Variance 101. You're here to consider whether or not the applicant meets the criteria for variance. Staff is issuing its recommendation with conditions. There have been other conditions that have been discussed. So the first order of business is for you all to determine that the criteria has been met. Because as the chair indicated, if the criteria as a board you all determine the criteria hasn't been met, then it's not about what was advertised or that, but whether or not the criteria has been met. Once you determine that the criteria has been met, then certainly it's appropriate for you all to consider any conditions, staff input, the property owner's input on what those conditions should or shouldn't be moving forward with whatever your recommendation is. And again, the generally speaking, conditions are intended to mitigate and ultimately resolve the variance issue or whatever other matter might be before you to, again, mitigate the impacts upon the public and on the property owner. And so that's,
Well, if staff is recommending approval, doesn't that in itself state that he feels that they met the conditions for approval?
you all have to make
Well, I
that
know,
determination.
but
But I get, where we are at right now is, we're going to stamp whether or not we approve of these conditions or not. And the conditions even change not only on them in the last minute, can change on us at the last minute too. And so I think that warrants some discussion on these conditional changes. That's all I'm going.
I don't disagree, and that's what you're doing.
Yes.
But I don't necessarily agree with the statement that just because they came before you now, they're not appropriate for you all to consider. You can consider any of them. You can say, you know what? No, we're not even going to go with the staff recommended conditions. It's your discretion, as long as you are making a determination that the criteria has been met, and to the extent the criteria has been met, are there appropriate conditions that should be imposed to ameliorate or mitigate the requested variance.
I'd just like to say that I feel like the buyer, under the conditions, has done a leap of faith in removing the front one to make the neighbors happy, and that she did not create this position. Unaware of the position when she bought the property, she inherited it. I'm willing to go with that she's met the findings and conclusions and meets the standards and the conditions for approval that were in the packet originally is what I would agree to.
You want to say anything?
Thank you, Lori Carroll. First of all, I appreciate you listening to this. It was a lot to kind of absorb. The day after the moving truck came in, we got the notice on the house, so that was our welcome. But
Welcome to Fort Myers.
but I understand and I appreciate the town wants to put closure on this. I think my biggest concern is that for that year period, there wasn't a sense of urgency to put closure on it. The fines weren't demanded by the other owners. They showed up. The first thing I did when I got that notice is came in, and it was Molly Jacobs and Sarah at the time. And they appreciated me coming in. They said most people come in and, guns blazing. And I said, listen, I want to take care of this. We had no idea this was going on. And they pretty much admittedly said, I don't know how this got lost in the system, but it did. And I don't think I should have to take blame for that. So it's been a lot. Ryan's been great, and everybody in the town's been helpful, but they want to close the loop. But in 2017, it was an issue. It wasn't an issue. They didn't want to close the loop. And somebody disappeared, and I showed up to face the music, and I'm doing everything that I can to make it right. My friends called me the safety hall monitor, so I like to do the right thing, and I think that's what we're doing. So I appreciate, your consideration, and it's been a financial burden. We certainly never would have paid, the amount that we did on the house, and here we are. So thank you.
Thank you. Appreciate the comments. All right, any other comments any discussion on our end? You want?
I'll make a motion.
I'm going back and forth on this 10-year piece, or do we just go back
Did I
with the
not make a
original?
motion?
No, you didn't.
Okay. No, okay. Go ahead.
There is a motion on the
I
table.
made a motion on, yeah.
Okay.
I made a motion on the table that I felt that she had met the condition, or the findings and conditions, and that I wanted to approve the recommendation or section, I didn't say section 34-14, or 1174 D1C, and section, is this right? Yeah. And 4-368. I'm inverting my numbers. I guess I would have put my glasses on. D3, C4, II, And the conditions for approval, I am recommending the ones that came in the original package.
Discussion on that?
I would,
Specific-
I would like to add to that the one-time thatching that was discussed. You get one thatching replacement, if you're okay with that. I'll second it.
All in favor? Say aye.
Aye.
Motion passes 6 to 0. Okay.
I'm sorry, I have to leave. I'm supposed to be
Oh,
somewhere.
I'm sorry. Okay. Well, we still have 1, 2, 3, 4, so we'll still have a quorum to finish up the rest of the day. All right. Oh, you're fine.
Had to park a block away. Hey, Jason, can we suggest that the employees park in the employee parking on this side of the building so that, I mean, when I came at 8:30 this morning, there was like 5 parking spaces left. I realized there was a meeting before us, but these parking spaces were all open, and so we had to park in the grocery store parking lot. So it'd be good if the employees could use those parking spaces. It's just a suggestion.
Suggestion duly noted.
Moving on to our administrative agenda, which we have the religious and institutional uses. Can we table that for next month?
That was why it's on there, is because we talked about talking about it this month, and I don't want to right now, frankly.
We're at 4 hours.
Yep, so it's on there just to say we're continuing to investigate it, I guess, and we want to have an open conversation with you. We've got a couple busy schedules here, so what I would suggest is we'll try to get you out some information that we can, instead of just opening the conversation cold here, give you guys, like I think I said, the existing codes, and then we'll talk about it next month. But again, with your approval, that one is subject to moving depending on schedules, because I think the next couple months are going to be pretty busy.
Okay, and our next item on the agenda is recess as the local planning agency and open as historic preservation board. Do I hear a motion?
So moved.
I second. All in favor? Aye. We're now the historic preservation board. I'm going to turn over to Scott Stafford at this time.
So we did not have a meeting last month. Going forward, Lori Wolf and Bev Milligan have been put on the board. I unfortunately am going to be out of town the next 3 months during the last part of each month, and with season coming up, I'm just not going to have the bandwidth to be on,
President of it?
even be on it, quite honestly. I mean, if we need me to be on it, I can do it, I just cannot.
Do I have any volunteers to sit on the historic preservation board?
Before you do that, can I touch on that?
Yeah.
There's a requirement that a member of this group is, I don't know why, but is also on that, even though it's a subcommittee to you. Lori Wolf is still on there, but she's not a representative of this group anymore, obviously, and Scott's not on it officially.
Not on it.
So you do have a hole to fill,
Yes.
whether you wanted Scott to do it or not. He's not. So whoever it is, they also have to officially submit the application, and then the council has to approve you for that group. And it's a weird thing where you're required to have somebody, but you also have to get approval by the council to have that representative from you on that committee.
I have a volunteer.
So there is an opening, thankfully.
I just don't have the bandwidth. I mean, I just don't right now. And I'm going to be gone the next 3 months. So that's not fair for our representation if I'm not going to be there the next 3 months.
Correct.
New guy.
I wish I could, but I've got a few things I'm working on as well.
I also have a couple things I might be working on in the next few months that could be challenging, so I'm wrestling with that as well.
We're at a quandary, because I know she's in the past has said she's too busy, and that leaves Dan Hughes, who's not here.
So you're required to have somebody. My suggestion is then if you don't have anybody, then we need to modify the ordinance governing those. So,
Is this something that we can rotate person through?
No, not the way it's constructed at this point, I don't think. I think it's an appointed member.
Well, to the extent that that an individual of this body says, yes, I'm willing to do it and submit my name, we have two individuals who aren't here. So, and I heard, I hear what you're saying. I would say that we put this on the agenda for the next, I have to
November meeting.
talk with, with Mr. Greeners, whether or not then until you all, or a member of this body volunteers and gets appointed, if the Historic Preservation Board can actually meet. But, that's what I guess, we as staff will reach out to the other two members who are not present, ask them if they're interested, and if they are, to submit their, submit an application. But until then, we won't be providing any additional reports.
Yeah, quite honestly,
I guess that's technically what will
I
happen.
don't know if we would even have I'm going to be out of the country next week, so, or when the meeting was scheduled, so I'm not even sure if we were going to have a quorum, because I think a couple of members are still not back yet.
So
Then
the
I'm
other
saying
option is
let's
change
table
it.
this, let's cancel the meeting coming up for next month. Table this to November, let's get everybody in here. I don't think that it's fair and polite to go and vote these people on, it's not appropriate. We're all struggling because we have busy schedules.
Well, and frankly, no matter what your vote is, they have to apply.
Yeah.
So, the other option is changing the language to designate as a liaison designate. I mean, but when all those ordinances and all those controlling documents were changed to kind of create consistency among all the committees and all that, that's where some of that language got changed. So you're in a unique position because the LPA is different than those other committees, but you also have a committee. So in the example of Lori, if Lori had been appointed to the LPA again, then she would by default, as also getting appointed to the Historic Preservation Committee Board, she would have been that liaison.
Yes.
So there's a flaw in the way the timing of them go, because if you get appointed to the Historic but not to this, you've broken that link. So it's a timing thing, and it's also maybe a requirement criteria. We can look at doing that too, if nobody wants to serve as a full-time member, but maybe as a liaison.
I'm still of let's cancel next month's meeting. This month's meeting, let's talk about this and put this on next month's agenda, and please don't pack our agenda with 5 hours.
Get things moving through, that's the instruction.
We're trying. Is everybody in kind of agreement on that? Does that sound appropriate and fair? All right, then, do I need a motion for that? No.
No,
There's no
frankly,
motion really
what we're
have.
discussing is almost self-effectuating, so, the only thing we need to verify on our end is that it is a mandatory requirement that before the Historic Preservation Board can meet, it must have a member, an LPA member on it. And if that is in fact the case, then they're going to get canceled until
It's not fair
one of
either.
the two individuals, or there's a change to the code.
Which probably we need to discuss next month then. I am making a motion to adjourn as the HPB and re-adjourn as the LPA.
Second.
All in favor?
Aye.
Aye. We're now to LPA again. Next on the agenda is the LPA items. You have anything?
No.
Dan?
No.
Great boat race weekend.
I heard
I said last month, I'm not going to be here the 12th.
Okay. So you will not be here November 12th? All right.
That's correct.
I did hear it was a wonderful, great event, and congratulations to all those who pulled it off. It sounded like it was a heck of a great weekend, and good for the beach. Next on the agenda items is the LPA attorney items.
Only one item, and it's really just a welcome to our new member and to remind him that you do have to file your initial financial disclosure, and it has to be done within, I think, 30 days.
30 days, yeah.
So
My goal was to go up there after this, but that's not going to happen
you
today.
can do.
Did you
Well,
file one for board cap?
I think that you can do it online.
Yeah.
Yeah.
Oh.
Yes.
And mail it
But
in.
with new technology, virtually every county now allows that to be done online.
I thought
So
I thought you had to hand deliver it. Okay, perfect.
You didn't have to do one for board cap?
No.
Okay.
Not that I remember.
Port Cab is this is a state mandated.
Okay.
And so the rules are somewhat different.
Jason, you have anything?
Welcome. We're available to talk. I offered everybody here, if you want to schedule things before our meetings, please schedule. I am not here next week. It's my first vacation in 10 years. So looking forward to that.
Go
That's
get
it.
some sun. You're looking a little peaked.
I'm going north. So, no, I'm doing my Asheville tour. So, but yes, I will be gone the whole week and try to be unavailable.
By the craft
But
beer.
if you really need something, you can 911 me if you want.
All right, any items for next month's agenda? Jim?
Thank you.
Dan?
No.
Tim? Okay, I don't have anything. All right, any public comment? Missy? Nothing? All right, so we'll close public comment. Do I hear a motion to adjourn?
So moved.
I second. Go ahead, Dan.
I'll second.
All in favor?
Aye.
Aye. We're out of here.